Excellent. Whoa. I've got a funky microphone, so bear with me. Welcome to the Sunshine Ordinance Task Force meeting, called to order at 4:10 on October 2nd, 2013. Madam Clerk, can you call the roll?
Member Nee?
Here.
Nee present. Member Washburn? Here. Washburn present. Member Pilpel? Pilpel absent. Member Sims?
Present.
Sims present. Member David?
Present.
David present. Member Highland? Member Highland absent. Member Oka?
Present.
Member Oka present. And Vice Chair Fisher?
Present.
Fisher present. And Chair Grant is absent. Do you have a quorum?
We do with 6, yes. Yes. Yes, we have a quorum. So I have 2 absences. Members Pilpel and Grant contacted us and noted they would be absent, and Member Highland will be here late, hopefully by 5 o'clock. Okay, so we have some agenda changes. Item number 4, file 12059. Both parties have agreed to a continuance for that, so do I have a motion to accept that?
So move.
Second.
Public comment, right?
You can, or if you want to.
You know what, hold off a sec, let's see who else is here. I want to see who I've got here. Item number 1, do I have Mr. Mianki in Rec and Park? And then we'll... Okay. Ms. Gong, is there somebody else that's coming too? Okay, we'll get to that. Item 5, Mr. Hartz, I've seen. Do we have somebody from City Light? Okay. And glad tidings may not be here yet, just because they know they're going a little bit later. And do I have anybody from the assessor recorder yet? Okay, we'll watch for the complainant. And Department of Public Health? I'm sorry, let's start with complainant or respondent? Respondent. Are the complainants here yet?
I am.
Okay. Okay. And let's see, last one, Planning Department? Well, they may show up. And, sorry, Mika Rinjo? All right, well, we'll watch for them when they get here. Anything else? Did I miss anything? Okay, public comment? You have 3 minutes.
I don't understand the reason for these excuses, because I don't believe it affects the provision in the bylaws that says if a member misses a certain number of meetings, then he's automatically dumped. So if there's a reason for the excuse which would sanitize the absence, then I don't think it's permitted under the bylaws. So I think you ought to check that with Mr. Threet's replacement before you go through it. Thank you.
Okay, thank you. Any other public comment on the agenda changes?
On the agenda.
Okay, Mr. Warfield, you can go next. Mr. Bianchi?
Peter Warfield, Executive Director of Library Users Association. I think that it would be helpful to the public and certainly to your concept of openness if you would give a little more explanation as to why the 2 parties are presumably requesting continuance, so that, for example, my public comment could be informed by whether that appears to be appropriate or not. We certainly know that continuances can be hard on the parties, but it's also hard on the public, who may be relying on your agenda to, for example, decide when might be a reasonable time to come in view of the other things on the agenda and their own plans, and so on and so forth. So I really think that it would be appropriate to let the public know whatever you know, especially if it was something that was provided to the task force other than a simple, we both, or I agree, and the other person says we agree that this should be continued. Normally, if something were resolved, we wouldn't necessarily be that interested in what happened to make it resolved, although I suppose I would be interested, but if something has been resolved, maybe we could hear what the resolution was. But again, if the complaint is withdrawn by the complainant, obviously there isn't very much that there is to be decided by this body. But here you're deciding whether to continue this. You have other options, obviously. You could say, we're giving one more time, or we're not going to allow this to be continued, we want to hear it tonight or not at all. Whatever it is, there should be some explanation. With respect to the previous speaker, Alan Grossman, I agree and have said this previously at a previous meeting. There is, to my recollection, and I believe at the time this came up, there doesn't appear to be in your bylaws an option for an excused or an unexcused absence. There is no definition of what it is or isn't. You seem to have assumed that if they tell you ahead of time, it's okay, but there isn't anything in the bylaws. So I certainly would like to hear what you think is excused or not excused. Thank you.
Patrick Burnett-Shaw on the agenda.
Yes.
I recall the new task force members having been installed, swept into office, as it were, saying that you would always uphold city attorney opinions. So it's high time that you start upholding your own bylaws. If these absences are inexcused and the members need to be replaced, then you need to make a motion and remove them from their seats.
If this is the wrong,
Mianchi?
hi, this is Dominic Mianchi. If this is the wrong time, tell me and I'll come back up later. But regarding the agenda, I would ask that the case file number 12058 be postponed for two reasons. One, Phil Ginsburg was asked to be at the hearing today, but since he was at a Record Park hearing, there may have been a conflict, so that we should probably postpone it to give him a fair chance to attend. Second, since there's only 6 of you here today, it would require I understand it would require unanimous vote, and Mr. David has already said that he will not vote for me, and I disagree with his reasoning that, because the Ethics Commission is going to overrule you, and that's why he will not vote for me. And I believe if I'm wrong, you can correct me. I don't agree with his reasoning because it makes your whole commission, moot if you're worried about what the Ethics Commission does. But because of that, I don't think it would be a fair hearing today. So for those two reasons, I asked it to be continued.
Keep going. No, you're fine. Do you have any more public comment? Okay, hearing none. No.
Beat you to it. Ray Hart, Director, San Francisco Open Government. And I, with the previous speaker, I heartily agree. I think it is really egregious to expect a person to come here and expect a fair hearing when they have to have a unanimous decision to prevail. It's just not reasonable. If you read the Good Government Guide, it says that a quasi-judicial body, which this is, has to have an appearance of fairness. And that means listening to the facts in the case and listening to the law in the case and making a decision. But if the tribunal it'd be like having a civil jury, which is supposed to have 12 members, and the judge says, oh, we're just going to have 6 members and decide the case that way. The courts would never put up with that. So I think in any case where you have 6 or 7 members who attend, and this is going on the previous comments by other speakers about this attendance issue. This was what one of the issues was for a long time with the prior task force, and now it's starting again. If you can't come to the meetings, you can't perform your duties. And when you take the oath of office, you take the oath with the idea that you're going to perform the duties, and at a minimum, you have to be here. And this continuing issue of having 6 or 7 members show up and having 2 vacant seats, nothing being done to fill those seats, this goes on for months and months, and very honestly, I think this is simply the action of the Board of Supervisors who are determined to castrate this body, to prevent you from operating by keeping holdovers, hoping that most of them will at some point get sick of being held over, and then leaving the 2 vacancies and refusing to have a hearing before the Rules Committee to appoint people to take their to fill the vacancies. They want to put the public at a disadvantage, and unfortunately what again we're getting into is the same situation we had when they replaced wholesale the last members of the task force when they found against the Board of Supervisors in the Parker-Merced case, where they just said, we don't like the fact that you decided against us, so we're just going to replace you all. We're going to refuse. And I think this is simply a continuation of retaliation by the Board of Supervisors against task force decisions which have not gone their way. And I'll be honest with you, I have made multiple requests of the chair of the task force about what she has done to talk with the Board of Supervisors about getting these vacancies filled, and I've gotten no responses. I mean, the holders are what? How long are you guys holdovers? 6 months, 7 months now?
A year and a half.
A year and a half. I mean, at what point does it become willful failure?
Okay, any more public comment?
Ma'am, are you going to take a vote on whether to postpone this gentleman's case? He specifically asked for a continuance. Don't you think you should do that as part of amending the agenda before you go any further?
Well, he's first on the agenda, so if you'd given me a second, I was going to bring that up.
Madam Chair, point of
Yes,
order, please.
yes.
There is one motion on the floor
Yes.
right now. It is to continue file number item number 4, file number 12059. I would respectfully suggest that we can take a separate motion regarding file number 12058 if somebody wishes to make it.
Okay, so we have one motion.
One
For the
motion
continuance
to
for item
continue
number
item number
4.
4.
Can we have that passed without objection? That was item 4? Okay. Member Nee was the first, Member
Was the
Washburn was the second. And do I have another motion, Member Nee? No, the one, restate the one you just made.
No, I said if somebody wishes to make a motion.
Okay.
I did not say I would make the motion.
Okay.
I move to continue file number 12058 because as chair of the Compliance and Amendments Committee, I had hoped that Phil Ginsburg would have been here. His participation is essential in this matter.
I second.
Seconded?
No, there you go.
We've got a double second over here.
You can, Mr. Oka.
So we have discussion. I know we go discussion, or we pass, and then public comment.
Public comment?
Well, public comment first?
We vote.
Public comment first? Okay, so we will go, bear with me, guys, my second time doing this. We're going to do public comment, then we're going to do discussion, and then we're going to vote on the motion. Okay, public comment? Oh, sorry, I was trying to explain it.
Thank you for continuing.
Public comment.
We haven't continued yet.
We haven't continued yet.
That's the motion on the floor right now is
Todd, I
to
got it.
continue your case as you requested. That is the motion. We are now taking public comment
So
on that.
let me repeat, because I need to know as to, Mr. Miyake, we're going to do public comment on the motion that member, was it Washburn, made. We're going to have public comment. Then the task force is going to discuss and vote. So hang tight.
What happened with item 4?
It passed without objection.
So it's being postponed.
Yes, it is.
Supposed to be a roll call vote?
Well, we passed without objection. Madam Clerk, we cool with that? May pass without objection. Okay. Mr. Monette Shaw.
So speaking on the motion, it would be useful, instead of referring to the actual case number, to instead refer to it by its agenda item number. I'm speaking in support of the motion to postpone this gentleman's case number.
12058?
What's the agenda item number?
Sorry, item number 2.
Item 2. I'm speaking in support of awarding him a continuance under your motion on the floor, because I am absolutely appalled by Mr. Todd David's stated rationale. I intend to file a complaint about that. It is not up to Mr. David to prejudge a case by alleging that he refuses to vote on any referral to the Ethics Commission. We just went through this at the Ethics Commission when they met on September 17th, and there was a debate about exempting the Ethics Commission as respondents in cases because they thought that they couldn't get around the conflict of interest. And during that Ethics Committee meeting, there was some discussion about, well, it's futile to send referrals to the DA or the city attorney or the AG, but the Ethics Commission pulled out their ethical reasoning and determined that simply because there was going to be a lack of enforcement to a referral to another agency, that they could not use that rationale to justify what they were attempting to do. Similarly, Mr. David, if the allegation is true, is refusing to listen and judge fairly based on the merits of a complaint, simply because he doesn't like the idea of sending a referral to ethics because they're not going to do anything, then Mr. Todd David should be removed from this body for not having any ethical compass.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I would, if I had known I would need it, I would have brought it along, but I would suggest you all go to the Good Government Guide and look at what a quasi-judicial body is expected to do to comply with the Good Government Guide. And the city attorney is always pushing that on us, so let's push back a little bit. It basically says you have to approach things with an open mind. And if someone states publicly that they will not make a finding prior to even having the hearing, they have shown they don't have an open mind. And one of the things that I'm having a real problem with is Mr. Pilpel, who's not here tonight, but I'm going to speak about it anyway, is the fact that Mr. Pilpel always sides with the city. Every single time he votes in favor of the city and against the complainant. And you know, when you come to this body, if there are 7 members and there's Mr. Pilpel as one of them, you know you've got to get the other 6 votes. And has been said before, as Mr. David is here, and he has on several occasions made public comment that indicated he did not have an open mind, you now then have to go to the point where you say, you know, is it worth having a hearing? And I'm having a debate in my mind as to whether I should ask for a continuation of my hearing because I will have to get 6 votes. It is unreasonable for you to sit there and know that if you were in the position where we are in, that you would consider it unfair, and yet to proceed as if nothing was out of place. You know, basically you're just saying you have to get a unanimous vote because our members aren't even willing to show up. And the ones who are willing to show up will be egregious in stating publicly that they will not make certain findings before even hearing the case, or making a decision, or hearing a motion, or a public comment, or anything else. I mean, the bottom line is your members need to show up. If they can't show up, they need to resign or be removed. The bottom line is you have to be fair to the public. That's what the Good Government Guide says, and not being here is not fair. Could Would any of you look me in the eye and say you think it would be fair if you were having a case as a complainant here against a city body and you knew you had to get 6 out of 6 votes to prevail? Would you think it was fair? And if you look me in the eye and say you would think it was fair, I'd have to look you back and say, I don't think you're being honest.
I think that in view of Mr. David's statement, he should recuse himself from this particular case matter. That would be number 12058. The fact that Mr. Pilpel isn't here is the same as his voting no. The fact that Mr. Highland isn't here is the same as his voting no. The fact that Ms. Grant isn't here is the same as voting no. And what we don't need, I think, we, talking for myself as kind of a advocate of the public's interest, is one of your members to be biased in advance before a case is heard. So I really think Mr. David should recuse himself because he's not going to give this complainant a fair hearing. In that case, you will lose your quorum, and what will happen is that case will have to be continued, and then you can move on. That would be the fairest way to handle it without, trying to demean anybody personally. It's just that that's the fairest way to handle it, and that's what I would suggest.
Can you make a public comment?
In David's defense,
Madam Chair,
Hold on a second.
this is a party in interest to the matter
Yeah.
we're voting on.
Yeah, I don't think you're allowed to publicly comment on this.
okay.
That's what that quizzical look on my face was.
Madam Chair, may I, since...
Let's
Sorry.
finish with
Yeah,
the public
sure.
comment.
I'd be glad to give my time if Mr. David wants to say something relatively brief.
No, go right ahead. I can wait till all the public comment. I didn't know you were up there. I apologize.
Peter Warfield, Executive Director of Library Users Association. I think it's truly appalling that you have only 6 members present. I recall the discussion when you made the rule change that had been worked on for a long time, and with the excellent efforts of Alan Grossman, to require a majority of the quorum only. And I recall your members, one in particular, insisting that, we are always going to be here and we will never have a problem with this issue of too few people to have a fair hearing. Well, that member is present today, to his credit. Where are the other 5 members? I would like to ask that member. It is unconscionable that you, in this format, require a complete unanimity from every single member in order for the public to have an official action taken. And so I think you certainly should follow the bylaws with respect to what to do about absences and absentees. I think certainly you should know it's important, very important, to come to meetings. And I certainly support the complainant in item 2 in the request for a continuance for this reason and others that he has referenced. I would also support a continuance on any other case where it is requested, and frankly, I think that you should not be willing to go forward with this kind of a total unanimity required. It's just not fair to the public. Thank you.
My name is Paula Dadish, and this was a big problem with the Arts Commission. There were commissioners who were repeatedly not showing up at the full commission level. There were very often the same people were not showing up. So I kind of looked it up, and even though that's an executive committee, there was a memorandum from the mayor's office that if any commissioner missed 3 meetings, they were supposed to report it, and it's never been done. It's gone on for years like that.
Do I have any more public comment?
Yeah. I would just.
Madam Chair, I would ask that the chair request that the public section be silent.
Oh, can we have silence in the gallery, please? Thank you. You're over there, I can't hear.
Yeah, I guess I just want to set the record straight that this Mr. Miyanaki's case, that the first time it was heard, I don't believe I ever mentioned the words Ethics Commission at all, and that it was based on I believe, if I remember correctly, that there was a very rich conversation between Mr. Sims and myself about what is appropriate to be redacted and what is not. So the accusation or the thought that I was solely basing a decision on what would be referred to ethics is, in my recollection, not true at all. I believe when it came back the second time, I expressed frustration that if we refer things to ethics and the ethics has a history of not listening to our cases, that was a frustration on my part and not the reason that I was not going to vote for it. So to, I think, present that I was predetermined on how to vote, I just feel that is a unfair characterization of my position on the 2 hearings. And I, once again, will vote in favor of, continuing this case, because I do think that it is difficult to get unanimous on, this case. But I just wanted to kind of set the record straight that this is the 3rd time, and the first time that I heard this case, the words Ethics Commission never even came out of my mouth. So that's it.
So we have completed public comment. We are now in the task force discussion of the motion. Member Sims.
I wanted to say, I'm in support of the motion.
Make sure you tap me. I'm not facing you guys.
For my main reason is that I think Phil Ginsburg should be here from Rec and Park. Secondly, I do feel that it's very difficult, for sure, to get a unanimous vote. I think under the circumstances, if we would go forward with any other cases, I mean, is it legal? Is it under our current guidelines, current bylaws to go forward? Yes, but is it per se just ideal? Under the circumstance, I don't think it's ideal. I know we do have one member who is on his way. So I definitely feel that after we have voted on this motion, I would perhaps ask that we take perhaps a 30-minute recess and then reconvene at 5 o'clock, do public comment at 5 o'clock, and then hopefully our member that is absent has shown up, and then we will have 7 members, but, we'll discuss that afterwards, sorry. But I just, my kind of issue with the, is that, just briefly to say that when we reconstituted, or when the board was reconstituted, it was my belief and hope that all members would show up for the hearings. Things happen, and people are late or miss meetings. That happens on every board of supervisors, and every committee. We are in a different situation where we are missing. We have holdovers and we have vacant seats, so we are doubly restrained unlike any other committee or board in the city. So I think there are some issues.
So I have a stack. I've got Member Oka, and then Member Nee, and then Member Washburn. Because you'll have something to say by then. Member Oka.
All right. Obviously, today is going to be a problem since we currently only have 6 members present. And to be quite honest, if I was on the other side in the public, I would want this body as currently constituted with 6 members doing business on my behalf. Because we have to realize that each of us has a responsibility to be attending each and every meeting that we have committed to. That is our job, that is our charge when we take on this responsibility. We do get sick, that's understood. But, I'm totally in agreement with people who say, if you take this job and you can't make it, get off.
Thank you. I think I have Member Nee.
Yes, I'd like to make a few points. First of all, on the motion, I would like a roll call vote on the motion itself. Second of all, I am somewhat troubled by the insistence on the part of some people, both in the public and here at the table, that we have more than 6 members present, or we somehow postpone. To bring that kind of argument forth is to say that, well, I know how so-and-so is going to vote even before a matter has been discussed.
Yeah.
And I don't think that we have the right to prejudice ourselves against any member of this body before a motion before a matter is taken up. There are reasons, certainly, to continue a matter. I don't think that's one of them. Finally, on the question of number absences, we are an all-volunteer body. Each of us has outside obligations that we must balance, including work, family. Some of us, once in a while, may become ill and unable to participate in a meeting. And certainly, if somebody is that ill, if I'm that ill, I don't want to come here and perhaps, spread contagion. That would be unfair to everybody here. So it's, absences are regrettable, but at some times they are necessary and excusable.
Anything else? So we've got a motion. Oh, go ahead.
I was just going to say, I totally agree with Member Nee in the fact that, I know some members of the public believe that certain people will vote a certain way. Just because someone has a tendency to vote or percentages of voting one way or another doesn't mean they're going to vote that way in every case. And I do feel like this board is open and that we do have an open mind, and we all come from different backgrounds, and we all use those different backgrounds to interpret the Sunshine Ordinance as well as the facts of the case differently. And so we bring that to the table. So we're going to have different opinions, but that's my beliefs.
And you're all over the place on a lot of our votes, so
Thank you.
I mean that as a compliment. We do have Member Washburn. See, I knew it. Member Washburn?
Well, just some reflections. I think it's interesting that we're contemplating not going forward this evening because there are only 6 of us. A 6 is a quorum, and we should be able to move forward and conduct our business. On the other hand, members of the public are correct that for them to prevail, they have to sway all of us, open-minded or not. It's a high bar. And so now you appreciate the situation we were in so many times before, and the former group of us, I was on the ad hoc committee that looked at the bylaws, and we did a lot of research, and we felt that in deciding to go with the rule of having a majority of those present be able to make a determination, we thought that was a legal thing to do. We had basis for doing that. When we voted on it finally here to overturn it, I was the only person who voted to keep that rule that we had decided on. So, we're in a quandary tonight. But I think I'm not in favor of not going forward because I don't know. I'm in favor of going back to the rule that we had determined after all the research we did, but we're not there tonight. So, but that's not the reason we're voting. I mean, I want to remind us why we're voting to continue this. It's because Phil Ginsburg isn't here.
Madam Clerk, can you reread the motion that I totally
The
forgot?
motion currently on the floor, made by Member Washburn, seconded by Member David, was to continue item 12058, I believe till the November meeting, or to the call of chair. That wasn't clear.
Oh, who made the motion?
I didn't specify. I just said,
Do we need to? I mean, can we just put them back for next month, or?
You have to specify.
You need to specify.
continue it to next month so that we can hopefully address it.
So we're going to have a vote, and a vote of yes means we're continuing it, and no means you don't want to continue it, correct? Okay, can we have a roll call?
Member Nee?
No.
Nee, no. Member Washburn?
Aye.
Member Washburn, aye. Member Sims?
Aye.
Member Sims, aye. Member David?
Aye.
David, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
You have 5 ayes, 1 no.
Because it's procedural, the aye votes prevail.
Yes. We know. We're there.
Yes.
Yep,
That's
we're
what I
done.
just said,
That's
Mr.
good. Yep, we're good.
Grossman.
Yep.
Because it's a procedural
So
vote, the ayes
the
have
motion,
it.
it's procedural, so the motion passes. Passed.
Through the chair, a point of
There's no public comment to this.
order on the agendas. I'm
Yes.
debating whether to ask for a continuance myself. And the
Mr.
reason-
Minetshaw, can you sit down, please? Or I'm going through the agenda. This is not public comment.
I'm not speaking on public comment. I'm speaking through the chair as a courtesy on a point of order about whether I should continue my case and whether that needs to be done during adoption of the agenda, or whether if Dr. Rivero, my co-complainant, does not show up before our case is held, based on the published times on the agenda, she is now unaware that 2 cases have been continued, and if she arrives late, I'm not sure whether I should go ahead and continue our case, or if I should go ahead and present our case tonight in her absence if she's not there. So am I allowed to ask for a continuance at the point that you get to our case on the agenda now that it's been moved up by 2 cases?
Yes, you're allowed to ask for a continuance when your case is called.
Thank you. That's all I wanted to know.
Okay, so I'm in a quandary because we are at item number 3, which is public comment, but I really don't want to start that until 5 o'clock. So do I have a motion?
No, Madam Chair,
Go ahead. Member Nee.
I believe we're at item 2.
I believe, I would,
Oh, no, I'm sorry.
No, we
My mistake.
continuanced. We continuanced
We continue
that.
it.
We continued that. So we are at item 3. Do I have a motion? Do I need a motion?
I'm sorry. I would suggest that since public comment is for 5 o'clock, it's not quite 5, maybe a recess for 10 minutes?
Yeah.
You can do that?
I think that's fine. I'll make a motion that we recess for 10 minutes and then reconvene at 5 for public comment. I don't actually think we even need a motion for that.
We don't need a motion. The chair can declare a recess.
I'll see everybody back in 10 minutes. What? Hello? What? Ooh, I can have half my sandwich.
Chris hungry.
Do I have to reconvene?
Just say we're back in session, right?
The meeting of the Sunshine Ordinance Task Force, October 2nd at 5 o'clock now, is back in session. Where are we, Madam Clerk? We are at I'm sorry. We are at item number, why don't you call the item?
Item number 3, public comment.
Do you want to take your job from you? Do I have any public comment? Oh, and for anybody that's new, this is public comment about anything. That's not on the agenda?
Not on the agenda.
That's not on the agenda.
Right.
Come on up.
After 5 o'clock p.m. on Wednesday before its Monday meeting last week, John St. Croix made available to the public, and probably for the first time to the commissioners, a new draft of the Sunshine Regulations with changes proposed to the regs. Those changes had been in the works since June and were in final form in July. Given the long interval, why didn't Mr. St. Croix send him here well before the meeting so as to elicit your comments? I'll let you guess that one. The draft was made available to the task force on Thursday because I sent it over to the administrator, and each of you should have received a copy. The big change was Mr. St. Croix's addition of 2 provisions that exempted the commission from taking direct complaints against Mr. St. Croix, his staff, and the commissioners, and also returning to the task force any referrals against the same group, forcing a complainant to bring a lawsuit as his only recourse. Considering the significance of the proposals, one would have expected a couple of the members of the task force and its paid advocate, I might add, Mr. Threet, to be at the meeting to object to those exemptions and also to make a stink as to why the task force was not given a chance to review the draft long before the meeting. No members showed up, but the usual Sunshine advocates were there, and as a result of their comments, the commissioners decided they could not adopt these exemptions. I should add the city attorney approved them. The commission has dismissed every task force referral in public records since 2004. I've calculated that's about 45 cases in all. Many acted on after this group took over the task force. Yet there's no blowback from the task force about it. What is my point? My point is that the commission and its director do not respect you, and you don't seem to have any interest in showing the commission that you care, where does that leave the public that relies on you for their help? To make matters worse, particularly with the 2 seats empty, the new members seem content to force complainants to get supermajorities for a favorable determination. So what does that say about their interest in making the task force a fairer, more accessible forum for complainants? All in all, those members seem to have as little respect for the organization as Mr. St. Croix, and no passion for the very right of public access for which the task force exists. If a member doesn't care about that, he or she does not belong on the task force. I repeat that, does not belong here.
Members of the Task Force, Ray Hartz, Director, San Francisco Open Government. This is Order of Determination 12050, which was issued earlier this year. For some reason, instead of having gone to compliance amendments, this was sent to EOT, where the chair, Mr. Pilpel, tried to dismiss it without accepting the fact that the clerk of the board simply refused to comply, and he tried to get rid of it. And then at that point, two members, Member Oka and Member Highland, and also Mr. David, voted to have another letter sent to the clerk of the board asking her to reconsider and to follow the order of determination. It has now been 3 months since that meeting, and this letter has not been done. Very frankly, I am at the point, and I may seem irascible at times, but at some point you really have to start to ask yourself, what in the hell is going on? Look at the two people who voted against this, Pilpel and Grant. And for some reason, the chair, Grant, decided to send it to EOT instead of compliance and amendments. And when it got to EOT, Member Pilpel, during the hearing, actually said some of us didn't agree with the decision. And now he is simply standing in the way of the task force's order of determination, simply refusing to even follow the advice of the vote of his own committee. They voted to send another letter to the clerk of the board. I don't know why they're doing that. As Einstein said, the best definition of insanity is repeatedly doing the same thing and expecting a different outcome. But at least if that's the vote of the committee, they should follow that vote. And very frankly, I'm looking now at the two people who voted against the majority of the task force and looking at it and saying, isn't it reasonable for me to assume that the two people who didn't approve of the decision are simply using maneuvers to prevent enforcement? Very frankly, this should have gone to compliance and amendments. Why it went to EOT has never been addressed. Now, at this point, I am really concerned because I've brought this up several times before to the entire task force. And one of the things that really disturbs me at a lot of public meetings, not just here, but in this city, is when someone will get up and make a statement which is just blatantly false. Like the vice chair of the police commission once told me there were certain things I was not allowed to talk about. And every other member of that board sat there and said nothing. And I said, you're telling me something that you know is not true. I'm allowed to talk about anything related to this body. And he said, no, you're not. We have rules against it. And everybody else just sat there silently. My question is, are you going to sit silently while your own enforcement is not done on your own orders of determination?
If you could let me know when 30 seconds are happening.
There's that big giant screen right there.
Peter Warfield, Executive Director of Library Users Association. You're hearing about an effectiveness of open government issues. Last month, there was a open government issue taken up at the California Fair Political Practices Commission, which found that City Librarian Luis Herrera had violated the law by swearing under penalty of perjury in 3 successive years on 3 successive annual required statements that he had received nothing in the way of gifts, when in fact he had received something, and in fact quite a bit. So my subject today is offenses subject to the penalty of perjury and City Librarian Luis Herrera. So what did Luis Herrera admit to in a so-called stipulation that he filed formally with the Fair Political Practices Commission? His statement said, I acknowledge that the violations of the Political Reform Act described above have occurred, and the violations that were described above was failure to report gifts on annual statements of economic interests. The press release of the Fair Political Practices Commission said, as follows. Luis Herrera, while serving as city librarian of the San Francisco Public Library, failed to report gifts received from the Friends of San Francisco Public Library on annual statements of economic interests, Form 700, for the calendar years 2009, 2010, and 2011. What did Luis Herrera sign? He signed on those statements that he had received nothing. I have used all reasonable diligence in preparing this statement. I have reviewed this statement, and to the best of my knowledge, the information contained herein and in any attached schedules is true and complete. I certify under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. What was not disclosed was tens of thousands of dollars in a city librarian fund, which I'm afraid you may not be able to see too clearly. 2008 to 9, $66,000. 2008 to 9, $65,000. There are a lot of issues here. The public, Mr. Chafee and Mr. Ray Hartz, were the ones whose research and efforts brought this to the attention of the FPPC and brought it to this conclusion. Thank you.
Thank you.
Yes, good afternoon. This is the first part of a two-part presentation on the context of the Sunshine Ordinance. Stop the corporate rape of our public library. Don't give money to the Friends of the Library. Don't accept money from the Friends of the Library. There we go. The President of the Library Commission has violated public's right to make public comment. And this is an actual recording of the meeting. This is part of the destruction.
Will you hold it until we get to it, please? Will you hold it until we get to it, please? You hold it? Are you not listening to me? The North sit down. The North sit down. And if it's down, please sit down. Please sit down.
This lady, it goes without saying, was not a donor to the library Friends. It was so obvious that this lady had an absolute right to speak that the Ethics Commission unanimously found the conduct to be below the standard of decency and constituted official misconduct. After that, the library posted on its website this recording of Ju Gomez plotting her revenge against a citizen, also not me.
And I used to carry a straight face.
Of course, the things that have been done to me are much worse. I've gone to Library Commission meetings, not only before there was a Sunshine Ordinance Task Force, but when I was the only member of the public in attendance. I should tell you that Jewel Gomez was not only returned to the presidency of the Library Commission, but Mayor Lee has declined any defense of why he has failed to remove her from office as the Ethics Commission requested. Sometimes we have to decide whether we want to benefit from the bureaucratic barriers or whether we want to benefit from the virtues of an open society. This does not happen in a vacuum. The Friends are able to perpetrate this level of abuse as a defense mechanism for their privatizing of the library, reaping millions of dollars per year in gifts to the library, gifts to themselves under the name of the library. When the mayor sees himself above the law and his allies is above the law, you're really saying that the truth doesn't matter in the face of money. Do you want to live in a society where money is the only value? In fact, the lies cost more than the money. Thank you.
And thank you for that nice multimedia presentation. Is this in PowerPoint?
It's PowerPoint.
We're happy to allow people to use PowerPoint. Thank you. Mr. Manette Shaw.
Thank you. I want to make 2 quick points. As I mentioned earlier, the Ethics Commission had attempted to exempt itself from having to adjudicate SOTF referrals alleging complaints against Ethics Commission members, ethics staff, and it was only through the excellent testimony of James Chaffee, Ray Hartz, Derek Kerr, Alec Grossman, Peter Warfield, and my own humble contributions that stopped them. They voted, finally, that they could not adopt these gross recommendations that Mr. St. Croix made, apparently catching them off guard about what he was up to. Interestingly, Member Pilpul, who frequently shows up at Ethics Commission meetings, often often appears to scuttle SOTF referrals to the Ethics Commission, didn't bother showing up at the Ethics Commission meeting. He should have been keenly interested about them trying to exempt themselves. And not only did he not attend, none of the rest of you did either. You should have come, and you should have told them there's nothing in the Sunshine Ordinance that permits any city agency to boldly attempt exempting themselves from the provisions of the ordinance. Second, just real quickly, this is related only peripherally to our complaint that will be heard later tonight, but when Health Commission Secretary Mark Morwitz submitted a draft of the minutes of the April 2nd meeting, I pointed out to him that he had not included in the minutes the sunshine provision to stipulate whether each speaker supported or opposed the record that was transpiring. Gratefully, Mr. Morwitz amended the draft, and he finally included statements indicating support or opposition. However, he has not to date adjusted the behavior of the Health Commission to include meaningful descriptions, even though he and the Commission know they are required to do it.
Last month, Ray Hertz said something that I've been thinking about off and on this past month, which is when somebody files a sunshine complaint and they're attacked personally for no reason whatsoever, just to shift the focus of, did you get the documents that you requested, off of that onto something else, it's meant to be very hurtful and to cut the person down so that they don't file additional complaints or that they feel humiliated or they feel they've done something wrong. And the first complaint that I filed, I felt that way, but I just realized that it's some kind of defense that people use when they have no other defense available to them to answer the question, why didn't you fulfill the immediate disclosure request? So I just want to say that I kind of got beyond that. It's a pretty wicked way of trying to get somebody to stop doing what they're doing, but just to make up a lot of nonsense is hurtful. Okay, bye.
Thank you. Okay, is that all we have for public comment? Do we have any more public comment? Hearing none, let's move on to item number... What? Yeah, I'm going to close public comment. Thank you. Oh, closing public comment. Oh, God, that's a little easier on that from now on. Madam Clerk, can you read item number 5, please?
Item number 5, file number 13013. Compliance and Amendments Committee has referred this complaint, Ray Hartz versus Lou Herrera, City Librarian, for allegedly abridging public comment by allowing selective accessibility of library audio-visual equipment.
So to clarify, we've already heard this case. It's just boomerang back from CNA, right? Member Washburn, perhaps you can.
Right, this matter was referred to Compliance and Amendments after the full task force found the city librarian to be in violation of some of the open meeting provisions of the ordinance. We heard the matter in Compliance and Amendments. Nothing had changed. The librarian, the city librarian was still maintaining that it would not be possible for them to allow members of the public to have the same access to the AV equipment as invited speakers, saying that it would cost, I don't know, $40,000. We weren't convinced. We still felt the way we had when the full task force heard the matter, so we decided to send it back to the full task force to decide what to do.
So it comes back to us. So, Madam Clerk, do we go with the standard 5 minutes each? Okay, so we're going to have the hearing, and for anybody that's first timer here, where the complainant is going to get 5 minutes. We'll have a public comment in support of the complainant. The respondent will get 5 minutes to make her case, and then we'll get public comment in support of the respondent, and then we'll discuss among the task force members. So, Mr. Hartz, as the complainant, you have 5 minutes.
Thank you.
Oh, I got a hand up in the back.
Public comment after the discussion for the public.
I was on the next page. I was on my next page, Mr. Warfield. I hadn't gotten that far. Go ahead, Mr. Hartz.
Okay. Ray Hartz, Director, San Francisco Open Government. As has been already stated, this has been heard before. There have been a lot of excuses given. There's going to be some finger pointing, which is the city librarian in this case is going to point and say, well, it wasn't my choice, it was the Library Commission, but they acted on his advice, and his advice was that they couldn't comply because it would require a $40,000 expenditure. I've repeatedly asked the Secretary of the Library Commission how other bodies or other groups that are asked to attend, give their input to the audiovisual sources, and my assumption is because all of the ones that I have seen have been in PowerPoint format, that if I submitted PowerPoint slides, they could simply include my slides just like anybody else. So I'm not asking them to spend $40,000. I'm not asking them to put up, some sort of a magical screen or something for me. I'm simply saying that you can't take one member of the public and deny them this equal access when they're actually opposing something that another member is given full access. Now, you've already seen earlier today in this very meeting the reason they do not want us, members of the public, to have access. This was a decision made by the Fair Political Practice Commission in Sacramento, finding Luis Herrera in violation for failing to report gifts that he received from the Friends of the San Francisco Public Library. What was not discussed at that hearing was the fact that while when he filed these things and perjured himself and said, I didn't get anything, he was overseeing a group which raises more than $4 million a year. And the library, nor the Library Commission, can produce any documents to show where that money went. They come in and make false claims. They simply say, the Friends told us they gave us $12 million, then it's $9 million, then it's $6 million. For a long time, it was $1.8 million. And what this really boils down to is when we bring these things up, they come up, use graphics, and show all of these numbers which are not correct. And then when we ask for equal respect and equal access, they go no, because they don't want us to put up things like this. They don't want this seen. They don't want it spread. They don't want it acknowledged that the city librarian, who has been found multiple times in violation by this task force for withholding public records, for denying equal access, for withholding the 150-word summary statements from the minutes. I don't know how much more he could do or not do to be considered willful. I mean, if I know that the law says you're entitled to something, and I know, to be fair, I should give that to you, and if I get an order that I should follow that order. But what the Library Commission simply did on Mr. Herrera's advice was ignore your determination and simply say they can't tell us what to do. In essence, the way I interpreted it is Sunshine Ordinance Task Force can tell us what the Sunshine Ordinance is supposed to say or what we're supposed to do in following it, when the law actually says that's your job. Your job is to tell other governmental bodies how this law is supposed to be interpreted and enacted, and that's what you did in this case. You said to the Library Commission, we don't buy your argument. You can give them access. You don't have to spend $40,000. We don't buy all these things that you've said about how difficult it's going to be or how impossible it's going to be. And most importantly, when directly asked questions in the original hearing about whether or not they would invite those of us as invited guests so we could access the graphics, their answer was no. Now, I don't know how much more clearly you can violate somebody's right to make public comment and to do so on an equal footing. The Friends between 2000 and 2012 raised $53 million. This is what they admitted to the State Attorney General's office. And the Library Commission and the city librarian for years have been coming before the public and saying, oh, this is a wonderful deal. Their primary responsibility is to look out for the interests of the library, and they have failed to do that. And in this case, Mr. Herrera was most egregious in this, in that while he was refusing to take any oversight, he was accepting gifts and perjured himself by denying that he was.
Okay, thank you, Mr. Hartz. Now we have public comment, where members of the public can have 3 minutes each to introduce facts and evidence. What? What?
In support. In support.
I'm sorry. Typo. Do I have anybody from the public who would like 3 minutes to introduce facts and evidence in support of the complainant? Well, they're public people commenting. I mean, it's semantics.
The procedure has been that you do this, then you have the other side and do that, and that you then have public comment at 3 minutes apiece after you've had whatever discussion
I use the term public comment not to be public comment, to be comments from the public in support of the complainant. So I mixed up. Look, come on back. I had my adjective and
The usual procedure has
adverb.
been for the complainant to present, for the other side, if you read your
Point of order, Madam Chair.
Yeah, go ahead.
The gentleman from the public is not part of the task force. Appreciate his desire to help, but for him to come up to the podium like that and insert himself into the proceedings is not appropriate.
Okay.
Public comment was called for, and I wanted to be sure that I would not be denied public comment through a procedural error by the chair. She's not following what the procedures here state in the agenda. Please read the procedures in the agenda.
Okay, well, complainant presents facts and evidence. Other parties come up in support of the complainant. Then a respondent will come up for 5 minutes. Am I getting this right, Madam Clerk? Okay, so is there anybody in support of the complainant? Hearing none, I will invite the respondent, who gets 5 minutes.
Good evening. Thank you. I'm Sue Blackman, the Library Commission Secretary, and I will be brief. We have issued a letter stating our position, and along with the draft minutes from the Library Commission showing their action based on your direction to me at the last task force hearing, that we take it back to the commission. And they did have a discussion and action. I do want to clarify one thing. On public comment, everyone has the same ability at public comment. There is no one that comes up during public comment and gives a presentation. The presentations are only for items that are on the agenda, and they are a presentation to the commission. And that's my statement.
All right, is there anyone, member of the public, that would like to introduce facts and evidence in support of the respondent? Hearing none, I will open it up to my task force members for any questions of the complainant, the respondents, or those who have spoken. Member Nee.
Ms. Blackman, please.
Counting on you, Member Nee. Come on.
Something you said kind of went by me. This is me, not you. But if you could, at the risk of making you chew your cabbage twice, re-summarize what you just told us. There was something that kind of popped in front of that raised a little red or yellow flag, and I just want to see if I can pinpoint what it is.
Okay, so the public comment part, everybody in public comment has the same 3 minutes to discuss. No one that comes up in public comment is allowed to use the audio visuals. So we're not discriminating on anyone's behalf or, looking at what they have to say. No one during public comment gets that opportunity. The presentations that are given are presentations that the commission has asked for. They are items on the agenda, and they are presentations to the commission.
How do you reconcile your statement with the contention that the refusal to allow utilization of the audiovisual equipment? How do you claim that doesn't abridge the right of members of the public to make their cases to the commission?
Well, they're basing that on recommendations or instructions from the city attorney that say that is not, there's nothing in the Sunshine Task Force that requires that we use that. The Sunshine Ordinance, it says that everyone must have up to 3 minutes in public comment, and that is what we do. The commission, I have the draft minutes for you. The commission did feel it was a policy decision by a policy body, which they are, that's how they're going to continue with their hearings.
Okay, but again, let me ask. If I want to use the audiovisual equipment to make a point, and you're saying, no, I can't do that, how does that, how do you tell me then that you're not abridging my ability to make my point to the commission?
Again, because no one under public comment is allowed to do that. We are not set up. If we were meeting in a chamber like this, where it's totally set up to do that, we probably, I'm not going to say that the commission would allow it, but more than likely the commission would allow it. We are not set up. We meet in a different building with a different setup, and it would cost money to make that happen.
How does it cost any more money to do that for members of the public when you're already doing it for certain invited speakers?
Again, it's presentations on the agenda items that the commission...
How does that not cost you money?
It does.
It does, okay.
Right.
But how does it cost any more money if the equipment is already there, already available for use by invited speakers? How does it cost any more money to simply leave it there, leave it set up, leave it available to members of the general public who want to use it to make a point to the commission?
It's additional money for every time you do a presentation. Someone has to set it up, someone has to put it in the computer. I'm not going to argue that point because the commission had the discussion. You can read in the minutes what their comments were, and they believed it was a policy decision on their part.
Melissa, hang on, let me get a
Thank you.
stack going. I did not see who was first. We're going to go Member Sims, Member Oka, Member David.
Well, I mean, reading the minutes
Remind me who I picked.
from your commission hearing where you guys discussed it, it is obvious that what you said is correct, that they believe it's a policy decision. But you realize that under the Sunshine Ordinance bylaws, that we are the only body that interprets for all city commissions what and how to interpret and enforce the Sunshine Ordinance Task Force. Do they understand that, or did they understand that?
No,
Did
they
hear
understand. I think they understand that, but we're getting different advice from the city attorney, and they are following the advice of the city attorney.
And you realize the city attorney is also not the body which determines the interpretation of the Sunshine Ordinance?
They are the body, or
Correct.
they are the department that advises the Library Commission.
I know. I understand that. But do you or does the Library Commission realize that statements made, I'm going to read the statement made by Joel Gomez, just so kind of you can comment on it, that the policy is the policy of the San Francisco Public Library Commission, and no other commission is in a place to see how our policies are enacted. You realize that when it comes to policies that enact public openness and openness of government, we are the only commission which is entitled to do that upon other commissions and the city, correct?
I'm not going to put comments, I'm not going to talk about comments that my commissioners made, because that's their point of view. So,
Well, I just feel like reading the minutes that it was maybe not given any seriousness, or it was given to interpreted that they're trying to tell us how to run our meetings, and essentially the vote that we were trying to do was to put you in compliance with the Sunshine Ordinance before we had to send you to ethics, or
Correct.
before we had to send you to a higher body for further enforcement.
okay, they were aware of that. They're following the legal advice of the city attorney. And, again, I cannot explain how they came up with that. I can't
Was
speak
that
for my
legal advice
commissioners.
printed anywhere? I didn't see that.
Well, what?
Was the city attorney's legal advice printed anywhere? Was
No,
it
it was
provided
verbal
It was verbal.
to the city librarian.
So
They're looking for it.
I would like to see the city attorney's written, not verbal, written comments or written opinion regarding that, because I do have trouble believing the city attorney told him that. I honestly do.
Okay, we'll request that from our deputy city attorney.
I believe Member Oka was, are you done, Member Sims? Sorry.
Yeah, I'm done.
All right.
Ms. Buckman, I'm going to ask you to give me a yes or no answer on this. Do you take down the equipment after the presentation is made so that somebody has to reset up the equipment for somebody to make that point by PowerPoint? Nobody has to reset up the equipment, do they?
Well, the equipment is on the
There
lecture.
already.
It's on the stage. We're not set up like this, where the equipment is here. The equipment is up on the stage with the Library Commission, and the public doesn't have access to it.
I'll tell you this, I can get up on that stage in 30 seconds and make my point in less than that. And if you're telling me that it costs extra money to do that, I have a real hard time believing that.
Member David.
I'd like to come at this from perhaps a different point of view. if a member of the public wanted to get on the agenda so that they could make their presentation in advance, is that possible? So in other words, as a member of the public, it's like, I have a presentation I want to do, during public comment. I understand that I'm not able to use the equipment, but I know I'm going to want to make a presentation using commitment. Is there a manner in which the public is able to officially get on the agenda so that the equipment is made available to them?
The commission chair, the city librarian, and myself set the agendas, and that's never been presented to us, so I can't answer what that would be.
I have that similar question. I'm on another organization. In our bylaws, it states that if you want to add something to the agenda, you have to send it to the chair 14 days in advance. I'm pretty deep in my own bylaws here, so I've never looked at yours, honestly. Is there Mr. Hartz might know. Maybe, come on up. Is there something that you know about?
Well, let me answer. There's nothing in our bylaws that says that. I mean, our bylaws specifically say that the secretary working with the commission president and the city librarian will set the agenda with input from the commissioners.
So I was, like Member David here, I was kind of looking for a workaround for this, because we're kind of committed to openness here and open government. We're just trying to figure out some way to make this.
Open it, and if you look at the minutes, I mean, all of the commissioners stated that everyone's treated equally, everyone gets their 3 minutes. If they want to bring in something, we can make it available at the back of the room, and they can read it during the they can send it to me ahead of time. I will make copies for the commissioners, and we will have copies at the back of the room. But that's
I hear. I'm just trying to bring into the 1990s, even the late 90s at this point.
I had a question. You mentioned that there's certain presentations that the commission approves of, and you're able to use the AV equipment. What are the nature of those presentations typically?
There have been several. We've had peer reviews on the branch libraries that architects have come in and shown, what's happening with the libraries. We've had updates from the community benefit district for this area, what they're doing, and how the library's money is being used to do that. The Friends have made presentations on their contributions to the library. So they're all issues that relate directly to the business of the commission.
Yeah, are you done?
And I was just going to say, so in your eyes, those are more important than what the public has to say?
No, they're not more important. The public has their 3 minutes to speak, and they can send information in ahead of time. I will make them available to the commission. We just are not set up to do the audio-visual.
Are you done, Member Highland?
No.
Wait, okay, Member Sims.
And I think we discussed this before, and I'm not going to kind of belabor it, but the last time you were here, we asked Mr. Hartz and we asked Mr. Warfield, have they ever been on the agenda for the public library? The answer was no. Has anyone ever been on the agenda in opposition to an agendized item to the public library commission meetings? And the answer was no. So you understand, because of that, the public and opposing views are not getting the same ability to present things to the public. And that's kind of why we're trying to teach or inform the Library Commission why we so want them to allow this access.
Yeah, I made my statement, and I have the commission's remarks, and there's not really much I can add to that.
I agree.
Yeah,
Okay.
we've all been there. All right. Do we have Member Nee? Member Washburn?
No, I think I've said everything I've had to say about this matter, and I'm as steadfast as I was before. I haven't heard anything new. I may have something to say later.
Okay, so we are at does anybody on the task force have any questions for the complainant? Okay, do I have a motion?
Madam Chair, rebuttals.
Rebuttals.
Okay, now in order, respondent has 3 minutes for rebuttal or conclusion. Respondent goes first. No. Where is she? Miss Sue, you have 3 minutes. You waive, okay. Then complainant, 3 minutes to offer rebuttal or conclusion. Yeah, I knew that was coming.
Ray Arts Director, San Francisco Open Government. Basically what we're talking about here is not just the Sunshine Ordinance, but the Brown Act. And it says you have to give equal access. And to say that we're going to allow one side to present and use audio-visual equipments and dog and pony show and whatever, but the other side is limited to being oral it's bizarre is what it is. Now, they say the city attorney's advice is that they don't have to allow access to the audiovisual. I would like someone to point out in the Sunshine Ordinance where it says you have to allow me to use the microphone. Can you allow one side to use the microphone and tell the other side, no, you have to speak without the microphone? So to make that kind of an argument is really ridiculous. But the bottom line is this. There are certain members of the public who attend the meetings on a regular basis, and we do so because we have seen things, especially as related to the Friends of the San Francisco Public Library, which are particularly egregious. And if we were to get up and say the things we say, they consider it bad enough that they have tried to stop it. They have tried to keep it from getting into the official record, the minutes. They have done everything they can to keep us from doing it, and now they're at the point where they're saying, good God, it's bad enough when they say these things. If we let them show it, we're screwed. And so what they're trying to do is prevent us from saying it. These are their own figures. $53 million between 2000 and 2012 was raised by the Friends, and 2 petitions to the Supervisor of Records, the City Attorney's Office, has established clearly that they have no idea where that money went. They have simply allowed the Friends to come in year after year after year and make statements of anything, and they've simply said, oh, thank you very much, that's wonderful. And those of us who say, wait a minute, we're told no. And the questions that were asked by this commission are very salient. Would you ever invite us to come and make a presentation? No, they wouldn't. Because that's exactly what they're trying to prevent. They're trying to prevent us from presenting it. And now we have the city librarian admitting to perjuring himself by denying that he accepted gifts from this same group at the time he was supposed to have the library's interests at heart. And he was looking the other way as to where this money went. We still don't know where the money went. And that's why this fight has been so tenacious. They don't want to show that the basic responsibility they have, both the librarian and the Library Commission, to look out at the interests of the library have been ignored for years. And our using the audiovisual equipment would be a damning situation for them.
Thank you. Okay, so that concludes our respondent and complainant rebuttal and conclusion.
I just wanted to mention that there were just a few of us at the last Compliance and Amendments Committee meeting where Mr. Chafee had a different PowerPoint presentation, and it was powerful. I mean, it was very slick. But that aside, the information was very powerful. So, and I think, it would be dangerous for the Library Commission to allow something like that to be seen.
Picture's worth 1,000 words.
Yeah, exactly.
I mean, just put some puppies and kittens up there and my wallet's open.
So, I mean, I just want you to know, I mean, you saw, it was more powerful than what you saw earlier, but what I saw earlier was eye-opening too. It just makes me madder than I was the first time I heard this and the second time I heard this. So, I just wanted to share with the rest of you who didn't see it that Mr. Chafee made the best case possible for the need for the public, for opposing points of view, to have equal access, because not having equal access just completely quashes their views, and the Library Commission and anybody that's there is getting a very lopsided, wrong picture of what's going on and is unable to balance. That's assuming they would want to balance and be fair. Maybe they don't. But I just wanted to say how well he made the case earlier.
I'm sorry, Member David?
Yeah, not being a metaphysicist, I don't want to look into the soul of the Library Commission and what their desire is or not their desire as far as, their fear of the public. But this seems to be a pretty clear case that the public is not getting the access that of equal access. I'm not going to pretend to explain it or feel that there necessarily is, a good reason behind it or a fearful reason, and I don't think that we're necessarily here to make that determination. I think we're here to make the determination as to whether they are following the Sunshine Ordinance Task Force or not, and I would say that in this case it's pretty clear that, from my point of view, that they are not giving equal access. I don't want to speculate as to the reason why they're not giving it. And I find it disappointing because as a user of the libraries, and my children are user of the libraries, I find the libraries to be phenomenal. And it's really actually very disappointing to me to hear that they're not, the commission is not open to kind of making equal access to the public to give public comment. So I'm not sure where it's appropriate to send this matter. I'm willing to support, moving it to the appropriate next level. I just am not sure where. If I don't know if Member Washburn has a recommendation from the committee on where it would be appropriate to be sent.
Yeah, I'm looking at you guys. It's got to go somewhere.
Yeah,
Go ahead,
Member
Mike.
Nee.
Well, okay.
And then Member Washburn.
There are any or all of 4 places to which we can refer this.
Not compliance and amendments.
All right.
Mr. Hartz would just be the boomerang person of the Sunshine Task Force. Go ahead.
The one place would be the State Attorney General. However, the State Attorney General on past referrals has said invariably, this is a local matter, we don't handle it. The second possibility is the district attorney. The district attorney, I'm guessing, would send it back to us saying, we deal with this only if we suspect there is criminal activity involved, or this is a criminal matter. We don't see that here, so we will decline to handle this. The third possibility is the Board of Supervisors. The fourth is the Ethics Commission. Now, the Board of Supervisors, when we have referred matters to them, have invariably given us absolutely no response. They've been totally silent. That leaves us with the Ethics Commission. And understanding the reservations that Member David has about this, still, it's right now, it's really the only game in town. And that's where we are. And finally, I would just make this remark, and I think perhaps Member David has already made it in another way, but that is, we're not here to re-adjudicate this matter. The matter has already been adjudicated. We have issued an order of determination. The question before us tonight is whether that order of determination was complied with. Our motion should be based on the finding, on that finding.
And I was just going to say, I'm sorry, on the floor.
No,
I mean, that's Ethics Commission has penalized members of the Library Commission before, so I don't know if, that is a sign that maybe they would be open to some type of penalty here, but...
I'm just going to jump on that. I'm not a real big penalty person. I just want the library to fix this.
No, I agree. And I think our goal is to fix it. And I don't think, my opinion is that unless someone higher than us tells them, you need to do this, you have to do this, you don't have to spend $40,000. You can do this on a low-cost, simple budget way. And I think that body needs to be ethics, and I think that should be our request of the Ethics Commission if possible. Not to penalize them, but to force compliance.
It was 6715D, right? That we...
The violations were 6715A and B.
A and D. Okay. Member Washburn, you have your hand up.
I don't see any reason why we couldn't send it to both ethics and the Board of Supervisors. I mean, the Board of Supervisors, has been silent on a lot of other issues, but that shouldn't stop us from letting them know the situation, and we could also propose a fix for this. This is a way that the Library Commission could accommodate members of the public, technically, or, I look at $40,000, I look at what the Friends of the Library says they give the library, and I'm thinking $40,000 is peanuts, and, given that auditorium is used by so many organizations for all kinds of events, it would be nice to have something set up anyway for, everybody to use, not just Library Commission meetings and members of the public that attend. But I'd like to see it go to both Ethics and Board of Supervisors.
Are you making a motion?
Actually, yeah. Madam Clerk, we've already adjudicated this. We've already found the violations. Do we need a motion now to... Okay, let's go then.
Public comment?
I move that we refer this matter to, and we have to name for the Ethics Commission, name the city librarian. Refer this to the Ethics Commission, also to the Board of Supervisors. Because for failure to comply with an order of determination to provide equal access to members of the public, because we found the library to be in violation of 67.15, which speaks to public testimony.
Friendly amendment. I'm just curious. Are you okay if we split the question?
So it's splitting the infinitive?
So, have one motion to vote for sending it to ethics and one motion to vote to send it to the Board of Supervisors.
Yeah,
instead of having to be two. Is that okay?
Yeah, I'm fine with that.
So, Madam Clerk, have you captured all that before we move into public comment?
Still have to second it.
Ooh, sorry, I jumped the gun.
Second.
No.
Oh, so I'm sorry. I just want to have a question. Which one are we voting on first? Or which motion is on the floor?
Oh, we've got two motions. Am I going to have two public comments?
What I suggest then, since the motion right now is for both sending it to Board of Supervisors and Ethics, that if you want to make two separate motions, as you as the one making the motion, or someone else can make the motion, but you need two separate motions if that's what you're asking, you're in agreement with.
Yeah, I said I was in agreement with splitting. There hadn't been a second on my motion. So I'm okay with splitting
Just so it's clear, because we're not sure, as a member Sim stated, what you're voting on first. If that makes sense.
So we're going to have two motions in 2 seconds. So far, we have one motion.
Right.
Right.
One
so
motion right now.
Let's go in order.
Okay, the first motion then, I move to refer this matter to the Ethics Commission.
I second that motion.
Pardon me?
So do we take public comment on there? Can we do two motions at the same time and take public comment at both?
We're going to double up.
And I move to send this matter to the Board of Supervisors.
And I second that motion.
Okay, so now we're going to, got all that? Now we're going to take public comment for members of the public who have not offered facts and evidence.
Thank you, Acting
Funny.
Chair Fisher.
You're welcome.
You all know.
Commenter Monette Shaw.
You all know Robert's Rules of Orders. You can only have one motion on the floor at any one time, and so a reasonable person might deduce that you can only entertain one at a time, and given the rules that you have to take testimony on each motion, there should be 2 public comment periods. But I'm not going to beat a dead horse. Instead, I noted with interest that Mr. David tried to qualify his remarks once again contingent on where the matter might be referred. Member Nee reviewed the abject failure of the DA to take anything not considered a criminal case. The AG abjectly refuses to take cases that are local. We're not really sure why the Board of Soups never respond. And we know what the Ethics Commission does, having dismissed all 39 cases that's been referred to them since 2004. But that is completely moot. None of it matters. Your concern, Mr. David, doesn't matter about where it's going to be referred to. It has to be referred somewhere. And you can't pick and choose whether you're going to rule in a complainant's favor or not simply based on where it might be referred to. That should not be a priori assumption before a vote.
Thank you.
Yes, thank you very much, task force members. And stop the corporate rape of the public library. Don't give money to Friends of the Library. Don't accept money from the Friends of the Library. In response to a request for use of the graphics by Ray Hartz, the city librarian responded with a letter dated March 5. It is available in your packet. That letter claims that providing access to the public that they already provide to others would cost $40,000. And that, quote, the library department does not have the resources to incur these additional costs. What does the library mean by that? In fact, the library has received 2 presentations of its budget before the Library Commission, and the library has what's called a library preservation fund, which allows their unspent funds to go into a reserve. On February 7, the Library Commission was presented with a budget for the fiscal year 13-14, which showed that the proposed budget was $100.5 million, and the reserve brought forward from the previous year was $17.5 million. In May, the city librarian announced orally that the controller was estimating another $3.1 million. By July 18, the Library Commission received another presentation which showed that the library reserve would be increasing $1.89 million, which means that this year's budget is over $100 million, and next year's budget is expected to be $104 million, and the reserve is expected to be a minimum of $19.3 million. Yet the city librarian tells you that $40,000 is something the library has no resources for. On February 2nd, the California State Librarian at the time, Stacy Aldrich, made a presentation to the Library Commission, including a PowerPoint presentation, since she was an invitee. At that time, she told the Library Commission that the way our minds are working and how we are getting information is changing visually. Interacting with information and communication is expanded. She also stated, quote, moving information from a text-based world to a much more graphic and more visual world is the responsibility of what libraries do. I think Stacey Aldrich was shocked when I told her that the Library Commission did not allow the citizens to have access to the graphics presentations. One thing I want to emphasize here that I did not emphasize in committee is that it is of the essence the difference between what you're being told and the truth. And the library sees their outrageousness of their lies and their power to get away with it of the essence. I don't know why you can't name the fascist black heart of these privatizers. I hope you will ask me about the Library Commission because I was in fact there. I can't cover everything in 3 minutes. Thank you.
Madam Clerk, I have a quick question. How are we seeing this? Do members of the public bring a USB stick and just plug it in? Is this sent to you in advance? Do we... No, I'm seeing it. How is it... I'm sorry, what is the implementation of this? Do they send this file to you in advance? Do we virus scan it? Or they plug it in on a stick? So it's a stick, and we rely that you didn't bring any horrible viruses with you or anything. So it seems pretty simple. Okay.
Yeah,
Thank you.
Seems like they could have a second laptop at the Library Commission. And
So this is the Sunshine Ordinance or Room 408 laptop that everybody uses. Okay. I forgot where we were. We're public comment, right? Okay. Sorry. I got so excited by the PowerPoint presentation. Sorry.
Peter Warfield, Executive Director of Library Users Association. They seem to be all over the place with respect to what's the defense, and I'll get into more of that, but I do think that you're in the right direction. I agree with Mr. Monet Shaw. You should have 2 public comments, but I will say that I favor both of your motions, but I think perhaps the egregiousness of this is very high because the Library Commission, in concert with the city librarian, openly stuck their tongue out at you, poked their finger in your eye, spit in your eye, basically told you, expletive deleted, you. I have a little thing that I didn't know what to do with, but I thought it was cute. So I thought I would put it here for you. It's a little keychain that flashes hot dollars. It would be nice if I could do as they do at the Health Commission, as they do at the Board of Supervisors, as they do at the Sunshine Task Force, if I could put this down to show folks what's happened, and in particular to give credit to the excellent work of the citizens that have worked on a particular recent finding a violation by another body. But I can't do that at the Library Commission because they make all these stories up about $40,000. It is interesting that the September 12th letter to the task force says the Library Commission met on August 15th and voted 6-0 not to allow the use and so on and so forth, because allowing members of the public to use audiovisuals during public comment would require the SFPL to expend significant resources, et cetera, et cetera. Well, we know that's utter nonsense, and that even if it cost $40,000, that is 4/10,000th or of the library's budget, 2/5,000ths of the library's budget. Did they get the city librarian to tell them that this is what they must do? They claim, without any documentation from the city attorney, that this is what the city attorney advised us, and I believe they say that in the minutes that there's no requirement to allow the public to use it. If you read what Jewel Gomez says, I think you'll find that contempt for the public is right there in the draft minutes. She said she does not feel like we are losing people's comments. She said they get plenty of comments that are articulated well enough for us to understand without the addition of audiovisual presentations. She said the only people we have using audiovisual equipment to make presentations are those with whom we do have a direct connection, which does not include people of the general public who just want to make comments. They have contempt for the public and for you, and you should take the strongest possible action you can against read their motion where they say let them leave their stuff in the back of the room and then explain it to people after the meeting. I might also mention that there's no record in the videos that they record of what would otherwise be visible if they were to allow it, so that they are essentially also abridging the public record.
Thank you, Mr. Warford. You know, I have that discretion. Let's go ahead. We got more public comment.
Public comment on the second motion.
Public comment number 2.
Through the chair.
Yes. Mr. Monet Shaw.
I neglected to mention that even though you've already adjudicated the case and it's coming back to you for review, this probably won't change what you've already voted on. But what this does display out of the Library Commission is a lack of generosity of spirit. Public Health Commission allows members to use their audiovisual equipment. They are not located in City Hall, where most of the hearing rooms that are either broadcast on SF.gov TV or otherwise do have audiovisual equipment. Notably, the Citizens General Obligation Bond Oversight Committee does not restrict generosity of spirit. When the equipment is available in City Hall hearing rooms, they have it there because they expect people who have been invited to make presentations on behalf of the city to have access to audiovisual equipment. It's unseemly that the Library Commission would exempt itself from that generosity of spirit.
Thank you.
Yes, thank you for this second comment. And of course, stop the hate, stop the ignorance. Don't give money to Friends of the Library. Don't accept money from the Friends of the Library. Let's imagine for a moment that you asked me what happened at that Library Commission, because a couple of your own members remarked on it, and it is of the essence. The Library Commission was presented with one letter to Mr. Hartz from the city librarian and one memo to the library commissioners from himself. No communication directly from you, no access to your letter of determination or what was constituted your deliberations, and none of the letters from Ray Hartz in response to that letter and responding to the city librarian's issues. So the Library Commission had in front of it nothing from opposition from the library administration's position. Now, in response to that, they said, well, that's great. Let's let the public bring things on paper and leave it in the back of the room, as if that was real communication, when in fact they had presentations from their own staff that illustrated points. They had, situations where they could recognize that direct visual communication was much more powerful than leaving a piece of paper in the back of the room, because you can stand, point to it, comment, and make your points in a connection between the spoken word and what you can actually see. And yet they claim that that means nothing to them, and their solution is to, you can bring it and put it in the back of the room. Well, in fact, they did not take a fair deliberation of your points, and, it was just not a reasonable position. Thank you very much.
Thank you.
Peter Warfield, Executive Director of Library Users Association. I want to thank the chair for allowing a second public comment. The 3, 6, 9, 12 minutes, I think, would be very useful and appropriate for your deliberations, particularly since this meeting is quite a bit abridged from the original plan due to cuts in the agenda. I want to read for the record the decision and order of determination dated August 19th, 2013, which is at the front of your packet. The task force and then contrast it to the wording of the Library Commission's motion responding to the situation. So what your order of determination on your page 127 says: the task force finds that the Library Commission violated Section 67.15A and 67.15B of the Sunshine Ordinance for abridging public comment by not providing equal access to audiovisual equipment by invited parties and the public. The Library Commission shall provide equal access to its audiovisual equipment and appear before the Compliance and Amendments Committee on September 17, 2013, for a hearing on its compliance with this order. What was the response of the Library Commission on your page 151 draft minutes motion by Commissioner Randlett, seconded by Commissioner Maul, given the concern that is being raised by the public that they do not have the ability to present materials through the audiovisual equipment to all those at the meeting in some type of presentation form, comma, that they do have the ability to bring materials in a printed form and that they use their time in public comment to be able to go through the materials, and that if other people have questions, they can ask the speakers at the end of the meeting in the back of the room. Now, one of the records the library provides is a video recording of its meetings, which is available upon request. It's not, well, I guess it's online now. If you were to watch that, you would not have the ability to see somebody making a point or to see any of the other things that their other folks get access to. And for this motion to imagine that it is giving any kind of comparable access to those who, quite rightly, one of your members says, are never invited to make presentations is just preposterous. Who do they think they're kidding? This body should take the strongest action, and so I support the motion, but I think you should also, even if there's not going to be a result or you don't expect one, send it to the other referring places you can as well. Thank you.
Thank you. Do I have any more public comment? Okay, hearing none. Ms. Osbury, let's go. Oh, I'm sorry. Public comment is closed. Let's go through these motions. Let's do them one at a time with 2 roll call votes. Can you read the first one?
On the first motion, made by Member Washburn, seconded by Member David, it's a referral to ethics. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
6 ayes.
Oh, you forgot Member Sims.
I'm sorry.
That's okay.
Sorry. And Sim, sorry.
Aye.
Yes, 7 ayes, sorry.
The motion passes. Oh, I say that? The motion passes. I wasn't sure if you said it or I said it.
On the second
Thank you.
motion, made by Member Washburn, seconded by Member David, referral to Board of Supervisors. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
Yes, 6 aye, 1 no.
Just want to do what we can here. So the motion passes. Okay, so then this is concluded?
Yes.
Okay. I see what you're saying now. All right.
We'll keep going.
So, Madam Clerk, can you call the next item, please?
Item number 6, file number 13012, complaint filed by Michael Aponanova, representing Glad Tidings Church against the Office of the Assessors Recorder for allegedly failing to provide complete records associated with Glad Tidings Church and San Francisco Teen Challenge.
So now, just to clarify, we are not going to hear jurisdiction on this because we already heard that last month. This is just was brought back for more information, right? So jurisdiction has already been settled, correct? So we are starting then with, we're basically starting with the hearing, correct? So we're starting from the beginning for the complainant will get 5 minutes.
I don't have a whole lot to add, just maybe for I think member David was not here last time, but basically, I just want...
You are?
My name is Mike Fontanova. I'm from Glad Tidings Church. Greetings, Madam Chair, and members of the task force.
You could be anonymous if you wanted to be.
Oh, okay.
You weren't last time.
No, I'm representing Glad Tidings Church. You can call me Mike because my last name can be difficult. I've already taken more time than I wanted to. I just basically wanted to let you know that, I requested documents from the assessor's office, and I feel they did not provide the documents I requested. Specifically, I'm looking for inter-office memoranda that led to them making the decision that they did make and revoking our exemption for a period of time, going back to 2009. I just want to look at some of the inter-office correspondence, specifically between Ms. Graham and Mr. Nguyen, as well as I'd like to see some of this information that they sent to the head assessor, who was Phil Ting, and then became Zun Nguyen, and then became Carmen Chu. So there was some differences in the way that each of our assessors looked at this. When we met with Phil Ting initially, he had said, all you need is this OCC, and you're all set to go. And so I'm trying to figure out why he thought that, and then Ms. Chu made a different decision. So I just want to know why that decision was made. I have talked a little bit with the respondent in this, and I believe they'll do their best to provide more information. I'm hoping that that is the case, and I don't have anything else to add to that.
Sorry. Choking me. Is there anybody that has... Somebody else finish this. 3 minutes.
Other parties of complaint, any other parties of complainant present to present facts and evidence?
Hearing none, let's move on to the respondent. Is the respondent here? Thank you. I just breathed the wrong way.
I know that feeling. Madam Chair and members of the task force, my name is Margaret Singh, and I do represent the Office of the Assessor Recorder. There's a bunch of things that council had advised me to say, but since we're not mentioning jurisdiction anymore, I'm going to cut it in half. But I did want to say that because Glad Tidings Church is the property owner assessee, the assessor recorder responded to the request using her authority under Section 408 of the California Revenue and Taxation Code. The state law governs access to records held by all county assessors, including San Francisco. Section 408 allowed the assessor recorder to provide Glad Tidings Church with certain documentation and information that are not otherwise public records or subject to public disclosure under Public Records Act. Even though the assessee's files are not open to public inspection under Section 408, in the instance, the assessor recorder is willing to try to resolve the assessee's complaint in this forum. I would like to begin with saying that since the last hearing, I did review the files, and I'm pleased to confirm that the office believes that all non-exempt documents that are responsive to this request in this task force complaint have already been provided to Glad Tidings Church. However, in the spirit of cooperation, I have brought with me today 5 documents that our office believes have been provided already, but are responsive to the request made at the September 4th meeting, and that are not exempt from disclosure, and we are making these available to Glad Tidings Church at no charge.
Well, does anybody have any facts and evidence to support the respondent? Don't go too far yet. Come on back. Okay, hearing none, I'm going to open it up to the task force members to question the complainant and the respondent. And I'm looking to my right. And I'm looking to my left.
Well I had so there are certain documents, obviously, that you have refused to, that are exempt from disclosure, that you're claiming they're exempt from disclosure under state law. Have you provided either a description or some type of what I would call in my legal dealings every day, a privilege log of those documents, which generally includes like the date of the document and a brief description that doesn't that tells them what the document is without disclosing any confidential information?
To my understanding, Francis Wynn sent him an email with attached letter addressing the documents, not specifically itemizing it.
Yeah.
But he did, if I can pull it out here, he did recite the evidence code.
Okay.
And that was dated March 28th.
That's right.
Member David?
I'm sorry, I'm going to say Mike. Would you please? Yeah, thanks. Sorry. Have you received these 5 documents that she just...
I haven't seen the documents she has today, but if she says that they've been provided, I assume they have been.
Do you want to give them to him?
Do you want to? Yeah, why not? Yeah. And please take a minute, look at them, and...
Okay.
Do those satisfy your...
No.
Okay,
Yeah, we
there we go.
didn't think
Let's
that
start with
was
that.
gonna happen.
Okay, so I guess my next question for you is that do you feel that I want to phrase this correctly, that the assessor office is working with you to try to resolve this, or do you, would a postponement for another month possibly get this resolved, or do you feel that, in your opinion, that you need a declaration from the task force in order to get the documents that you need?
I just don't understand the nature of the comments Ms. Singh made. She said that there was exempt, much of what I'm requesting is exempt for some reason. I think just to try to, I don't know, the matter's been confused in the past because it was asking about the complainant who's complained against us in a different matter, and they were saying, well, we can't provide you the identity of that person. I don't care about the identity of that person, and if that's an exempt document, that's fine. What I'm specifically looking at, wanting, is just, it says right here in our agendas about my rights, that government's duty is to serve the public, reaching its decision in full view of the public. I just want to know how they reached their decision. And I want to be able to show an appeals board or the Board of Supervisors or a Superior Court, which it looks like we may end up there, why they made a decision in error. And part of that, I believe, will be through documentation, through their in-office correspondence, whatever, Ms. Graham emailing Mr. Nguyen or whoever about what they think is going on and why they think that's going on. And so I can say that's not the case here, and so this decision was made in error, and let's reverse this and get it to the right place, because they're basically billing us at this point a property. We're a nonprofit organization, as I mentioned last month, that we've been here for 100 years, and I just want to know if there's documentation, if there's emails between the exemptions unit and the deputy assessor and the assessor itself that would show them how they came to the decision that they made and why I feel it was an error.
And just to be clear, when you say the exemptions unit, because we use exemption in a different way, you're talking about tax exemption.
Exactly.
I just want to be clear.
Which Ms. Singh is the head of the exemptions unit.
Because exemptions mean something a little bit different at the task force. And so,
okay.
Ms. Wynn, can I ask you a question? Same. I'm sorry. I apologize. My bad. To your knowledge, do any of these documents that, I apologize, Mike wants, do they exist?
To my knowledge, I filtered through all the emails, and whatever documents that were allowed to be provided were provided.
And when you say allowed, what do you mean by allowed?
So council basically reviewed all of the emails, internal emails, and she pulled out the ones that were exempt.
And did she give a reason for I'm sorry, did Member Sims already ask this question? Did she give a reason as to why they were exempted?
She actually cited Section 408A, which indicates any information and records in the assessor's office that are not required by law to be kept or prepared by the assessor. Disabled veterans exemption claims and homeowners exemption claims are not public documents and shall not be open to public inspection. And then she also referred to Section E1 with the respect of information, documents, and records other than market data as defined in subdivision D, the assessor shall, upon request of the assessee of property or his or her designated representative, permit the assessee or representative to inspect or copy all information, documents, and records, including auditors, narrations, and work papers, whether or not required to be kept or prepared by the assessor relating to the appraisal and the assessment of the assessee's property and any penalties and interest thereon. Then she went on to cite Section 3, 4083, which indicates, and this is except as provided in Section 408.1, an assessee or his or her designated representative may not be permitted to inspect or copy information and records that also relate to the property or business affairs of another, unless that disclosure is ordered by a competent court in a proceeding initiated by a taxpayer seeking to challenge the legality of the assessment on his or her property. So I think that was the information you were asking.
It sounds like that last clause you read is
Yes.
exactly what we're talking about. Okay.
Any other comments? Go ahead.
Well, it sounds like, I mean, maybe we should expand upon that, because it sounds like the last clause would make those records public. I mean, not public, excuse me, at least.
Can we get a reread of that last clause?
At least providable to the entity.
Member Sims, can you read that last clause? I apologize, I was reading a letter.
Except as provided in Section 408.1, an assessee or his or her designated representative may not be permitted to inspect or copy information and records that also relate to the property or business affairs of another, unless that disclosure is ordered by a competent court in a proceeding initiated by the taxpayer seeking to challenge the legality of the assessment of his or her property.
So, I mean, basically, the state law says, I mean, a court would have to order disclosure of it. And a court would. It would be part of the, discovery.
Through the chair, does the city attorney have any advice on this?
Yes, DCA Lee.
Well, welcome to the meeting.
Yes, hi,
Thank you.
welcome back. You've been here with us before.
I actually, it sounds to me, I'm not familiar with this particular Revenue and Taxation Code section. This is the state one or the city?
This is state.
State, okay. But on its face, it sounds to me that it needs to go through the Superior Court process, but I think the member's assessment is probably the same, so I'm not sure I'm adding much.
Well, you are
I don't think we could.
DCA. You are the deputy city attorney. You're adding plenty.
Yeah, I just don't think that I don't know what more of those documents that have been marked as not to be disclosed at this point under that statute that what more we can give him. I don't know if there is any more we can give him.
This is one of those things where we're the Sunshine Ordinance, so we can do this much, but you kind of need this much, right?
But, I don't know if any other members have any other thoughts.
And look to my...
Well, I think we have to determine whether we do have that authority and whether we can push this forward or not. I don't know if perhaps some people with institutional knowledge of this, we've come across this 408 in other cases.
Well, this is kind of a tough one, but I was looking in section 67.24, which is public records that must be disclosed, or public information that must be disclosed, and the kind of information that is being sought here, I don't see it as listed in 67.24. The other thing is that when there is a conflict between the California Public Records Act and the Sunshine Ordinance, Sunshine Ordinance prevails. When there is a conflict between the Sunshine Ordinance and another local law, sunshine ordinance prevails under 67.36. But
I was about to say.
the evidence, the code that Ms. Singh is referring to, did I get your name right?
Yes.
Okay.
Thank you.
The code that Ms. Singh is referring to was 408, I think you said?
408.
408. I'm not sure the sunshine ordinance can supersede that. And I wish that we had a sunshine ordinance specialist, a sunshine specialist attorney on hand for that, with all due respect to Ms. Lee. But it appears to me that our hands may be tied on this. That's my offhand, regretful assessment. We're not bumping up against CPRA here. We're bumping up against something else that may well be beyond our ability to supersede.
I mean, this has happened before where we've sat here saying, oh darn, we're just the Sunshine Ordinance Task Force. There's just, I mean, we're real limit, we have a limit on what we can do. I'm looking left and right. Member Oka?
Member Lee, the Sunshine Ordinance does not say that we cannot rule on this, does it?
No, it does not say that, but the question is, what would our ruling then be? If we wanted to find a violation, which section would it be? And particularly since the complainant does have other avenues open, as the respondent pointed out, there are certain kinds of documentation or evidence or correspondence that are obtainable, but only by order of a court, only by court order. And as much as I would like to say, yes, we would, order your complete cooperation in this, I'm just not sure that we have that kind of power here.
In this case, I tend to agree.
So could I ask a question of Mr. Pondanova?
Excellent pronunciation, yes.
Thank you. I'm assuming that in tandem with this, maybe you've already initiated proceedings with the legal court to...
Well, the first step that we were directed to take by the assessor's office was to go through the controller's office, file an appeal for a refund. So we had to shell out, more than half of this fine and then appeal. And so that appeal's already been denied. And so now we're left with a request to file an action in Superior Court. And part of the reason that this is important is because when we do file that action in Superior Court, one of the defenses we can offer is that we were led to make decisions because of the advice given by the assessor's office, and it was given in error. So basically, we have a religious exemption. They said, well, you guys need to get a welfare exemption. Okay, we get the welfare exemption. Now they're saying, well, now you got a welfare exemption. That doesn't work. No exemption. So, it was, not to say, we were led down a garden path, but that's what I'd like to show, and so I'm asking for documentation from the assessor's office about their thought process and the way that they came to the decision so that I can present that in court and say, here you have it. And if we have to wait till we go to court, then so be it. I don't really like the idea of doing that. I don't want to go to court at all. And my hope is actually that we can work with the assessor's office directly to resolve this, but it doesn't seem like, two of the major people involved in this are gone. And so Ms. Singh is here a month, and she's left to try to figure this whole situation out. And, I don't envy her position, but I know that there's more out there that's not being disclosed. And whether or not, if it's something that's subject to exemption, then like Member Sim suggested, why not present me a list of things that I can't have because they're exempt? Because I'm asking for something I think shouldn't be exempt, and I don't know if maybe I don't know the law well enough. I probably don't. But I don't know. I've probably expounded way more than you wanted on the question, sir.
Thank you.
Actually, I don't know if this is relevant, but is this judgment or situation, is this against the church or your Teen Challenge building on Valencia?
It's 1280 Webster Street, the church's building.
That's like a huge 100-year-old building.
It is, right?
I've actually been there.
You have?
Yeah.
Oh, awesome.
I get around. Jewish girl that gets around.
It's good.
This is the church. I mean, I get
Yes, the
around.
church, and they've removed an exemption on 2 of the parcels of the 4 that are there. So
I mean, I just, church, tax exempt. That's
it seems that way to me as well.
Member Sims.
I mean, in my reading of kind of the law, at least when it comes to actually getting the actual documents, this may be something you may have to just get in general discovery in Superior Court. That it may be out of our power to order the assessor to give you those documents under this circumstance. That didn't say that's the case under all circumstances. I don't know yet. However, I don't know if the assessor would be amenable to at least giving him a detail more of the documents that he's not disclosing or she's not disclosing based upon this use of this ordinance. I mean, that is something that maybe we could order her to do.
To provide a list of documents being withheld?
Well, a small description of a document, or the date of the document, or what we would normally do in a legal matter, like a privilege log, just a log of the date, the to, the from, and email or something. I don't know. I'm just talking.
Member Washburn.
Trying to come to a conclusion here.
I mean, that is part of the ordinance, that if you're withholding information, you have to specify what it is you're withholding.
Yeah.
And give the reason for it.
Mm-hmm. We've gotten the reason. It's just...
Did we get a reason?
Yeah. Well, no, she gave us a clear reason. I think she gave us... at least my belief is that she gave us a clear reason. But I don't know if she specified. To the extent that they should, to be fair.
No reason.
So
I can go either way.
Do we have a motion? Let's go with that.
So I guess I have a procedural question. If we as a task force want to, this is just a hypothetical, if we want to dismiss this, do we actually, I always forget this, do we make a motion to dismiss?
No, we just declare it concluded.
We just say it's spoken, but we still have to take public comment.
That is correct.
So this is where I get confused. So we make, if theoretically we want to dismiss it, we would make no motion.
So I'm glad you asked that, David. Let me clarify that for you and everybody else in the room.
Yeah.
If there is, I look left or look right, if there are no motions, the chair declares the matter concluded, but we still take public comment, 3 minutes per speaker.
Thank you.
Do I have any motions?
Or are you done talking? I'm sorry.
Rather than making a motion, can we suggest to the commission, friendly suggestion? I mean, it doesn't carry any weight, and they realize they don't have to do anything, but they seem to be making overtures of trying to cooperate. At least a list of what's exempted. At least give him something to work with in the future.
Did you want to say something about that privilege log? I was kind of leaning towards that.
I don't know if the...
Yes, actually,
yes. What are your thoughts about what you're willing to do or could do?
Well, you're suggesting in compiling a list, majority of the emails that I did filter through, we can provide the dates, whom and from if we're even allowed, and the subject line, but the subject line is very generalized. It just says Glad Tidings Church annual fund, annual exemption, or whatever. It's not going to give anything.
Yeah.
So it's kind of redundant, and he's not going to be able to use that in court.
Yeah. Yeah.
Well, Madam Chair.
Yes.
The real question here is whether the information, whether what you are just referring to is disclosable or exempt or prohibited from disclosure. That's really the consideration that you have to deal with. So if whether or not it's going to help somebody in court, that's not a matter for us to decide or to consider. What's for us to decide or consider is this disclosable under California law and under local law?
Member Sims?
I mean, even if they give a list, it'd literally be, like you said, I mean, like the subject line, the to the from, but it could give him a record of these documents are out there, and I know these documents are out there, and when he goes to actually give a document request in his Superior Court proceedings, he can take that list and say, I want all these documents. I want everything, and make sure these documents are among them.
I've got a quick question for DCA Lee. I'm not a lawyer, clearly, but I'm remembering from something many, many years ago, because I was in a similar situation where you got this privileged list, but then there was, what's it called, an appointed, not trustee or somebody that actually reads all these to determine whether there is something. What's that called? Maybe you know, maybe you know.
You may be referring to in litigation, what's a discovery master? Is that
I know. We don't do litigation here, but yeah.
Okay.
I mean, you can do an in-camera review, but that's not going to happen.
I was just wondering if that might be helpful.
Well, if
somebody else says, all right, I'm looking at these.
I'm not going to comment on whether something will be helpful or not to the complainant, but I would like to focus the task force on the issue of whether these are actually public records subject to disclosure.
Yeah.
And under that question,
under state law, because if they're outside that universe, and from what Ms. Singh read, it sounds like the avenue may be elsewhere. But if the assessor's office is offering to provide a list or a log or whatever have you, there is no provision in the log, in the sunshine ordinance for such a log. But if they're willing to do so, then that could be an avenue.
I'm sorry, Member David, I did cut you off.
I just feel like that this is like one of the situations where the assessor is actually providing us with the reason that they are not, that these are exempt from disclosure, and we, as a task force, always come to the departments and say, what are your reasons that you're not disclosing this? And she has come back with very detailed reasons, and now we're coming back and going, well, yeah, I mean, it seems to me that it's pretty clear that this is not within our, I certainly hope that Glad Tidings Church gets the information that it wants to get, but I cannot see anywhere where there's a sunshine violation in this situation. The assessor has been incredibly clear and diligent and precise about why they are withholding certain documents. It doesn't fall between, it's not documents that have to do with sunshine or the Brown Act or anything like that. So I'm a little bit perplexed as to what we are trying to...
I think the answer is we're human beings, and not liking the reason, unfortunately, is not enough of a good reason for us to move forward in this. But we don't like the reason, but it doesn't mean that we can't use that as Sunshine members. So I'm with you on this. Pastor Mike, you had your hand up.
Is it okay for me to talk? I don't know.
Yeah.
I just had a question. If it's the determination of the members of the task force that the information I'm requesting is indeed exempt, then okay. I'm not going to, you guys are wrong. I'm not going to, I think some of our friends are gone that might do that, but I just,
Oh, yeah.
I'm fine with that, and Ms. Singh's been very cooperative. I think, we can work something out. Hopefully, I'm hoping we can get a meeting on the books where we can talk about this in more detail, and I would like to have some of these emails and things in front of us so I can say, Ms. Chu, the assessor, the current assessor, here's something that Mr. Ting said. Why are we not looking at that? But if you're saying, well, I'm sorry, we can't get you that information because it's exempt, which I heard her read all that legal jargon, and I don't understand anything she said, but the fact that she said it was exempt, maybe it is. If you're saying you agree with that assessment is exempt and that means that you can't do anything, that's fine. I'd actually probably pay you to never have me come back to this and have to listen to Ray Hartz or any of our friends there. But, and I think Ms. Singh's with me on that, man. So, we'll try to work that out. I'm not here to, pick a fight. That's not my point, so.
So hearing no motion or any other
Madam Chair,
comment, yes, Member Nee.
Just a point of order, have we had rebuttals?
Well, yeah, we kind of did. We brought, I'm going to,
Okay.
would you like more rebuttal? We did have the respondent come up first. Ms. Singh spoke, and then Pastor Mike spoke. Do you have any more rebuttals to your rebuttals? Or pretty much? Because Member Nee is correct. I kind of let you guys flow up here in the proper order, but it wasn't really official. Do you officially want to rebut? Come on up.
Let me just say
You have
this.
3 minutes.
Okay, let me just say this because council advised me to.
Bring it on.
With all due respect, if Glad Tidings Church believes that the Assessor Recorder's Office has improperly denied inspection and/or copying its files, then it may submit a new request to the Assessor Recorder under Section 408 or take action in Superior Court. But in all honesty, I have been cooperating with Mr. Fondanova, and we did speak this afternoon, and I'm trying to schedule a meeting amongst all the stakeholders so we can...
Everything that you just read, which was very informative, you're going to give that to him written down so he could, because it would take me 4 times to reread that to understand what you just said.
I speak fast, sorry.
So you'll give that to him, right?
She just gave that to me.
Okay,
She gave
just
that
checking.
advice just now.
I'm a visual learner. Auditory flows right through me. Okay. Give her, do you need a few more minutes? I took half your time.
No,
Okay.
that was it, thank you.
Pastor Fondanova, you have 3 minutes.
Can I get the Friend of the Public Library number so I can call them for donations? 53 million. Wow, that's amazing. All right, thank you.
And their PowerPoints. So I'm going to declare this matter concluded.
I think
What?
she maybe asked if there is any. Did you?
No, we declare the matter concluded, and then comes public comment.
Does anyone have a motion?
Well, nobody had a motion to make.
Still to ask. Still to have.
Madam Chair, let me
Member
just
Nee?
suggest that the chair call for a motion. If no motion is offered, then open it to public comment. Once
Okay.
public comment is over, then we declare the matter concluded.
I guess I called for a motion, but I did it off mic. Do I have any motions? Who are you? Member Sims? I'm going to look to my right. And then I'm going to declare this matter concluded, and then we open it up for public comment. The matter is open to public comment. 3, 2, 1, hearing none. We're done with this one. Do you want a 5-minute break? Yeah. I can't read that. Is it like 6 minutes to 7? We're going to be back here at 7.
Thanks, guys.
At 7:03 p.m. on October 2nd. Madam Clerk, could you read the next item?
Item number 7, file number 13021, complaint filed by Patrick Malaysia and Dr. Maria Rivera, against the Public Health Commission for allegedly violating Sunshine Ordinance 67.7A, 67.7B, and 67.9A, failing to notice members of the public and noticing a deficient agenda.
Okay, we haven't heard jurisdiction on this one yet.
Madam Chair, move to accept jurisdiction.
Okay, we have a motion. Do I have a second?
Second.
Okay. Wait, just give me a second here. So we have a motion and we have a second. Can we just pass this without objection?
Public comment?
I'm getting there.
We'll do public comment on the note.
Okay. I'd like to hear public comment.
I wasn't attempting to rush you, Mrs. Fisher. First, I'm going to ask that when you get to hearing our opening statement, that you set the clock for 2.5 minutes for each of us so that we can have an equal time addressing you during the opening remarks.
So you mean the 5 minutes? You want to split that?
I'm sorry, yes, the 5 minutes.
You want to split?
But I want you to set it for 2.5 so that each of us can have half of the 5 minutes.
Yeah, okay.
We consciously chose.
Madam Chair?
Yeah,
Point of order?
Yeah.
We're on jurisdiction now, Mr. Mayor.
Yeah, we're on jurisdiction.
I'm addressing jurisdiction.
Well, but you're a party in interest right
Yeah.
now. This is public comment.
Yeah, you're a party of interest to this item, so is there any public comment for anybody in the gallery that is not party to this? Hearing none? What? Hearing none, then I guess we just go right into the,
Vote on the motion.
we have a motion, right? Let's do a roll call on the motion to accept jurisdiction. A very quick one.
Member Nee?
Aye.
Nee, aye. Member Washburn? Aye. Washburn, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
You have 6 ayes.
Motion passes for jurisdiction, okay.
With 7 ayes, right?
7 ayes. So now we're going to move into the hearing and action on the substance of the complaint. So we're going to hear from the complainants for 2.5 minutes each, and then we'll hear from the respondent. Did I get that right?
Yeah.
Okay. What? What did I mix up?
2.5, then we're going to flip? Is that what we're doing?
Well, we're going to go with the complainant, and then any members of the public in support, and then we're going to go to the respondent, members of the public in support.
Got it.
I got it.
Thank you. Given DCA Lee's September 26th instructional memo, it appears she has upheld all of our allegations regarding the lack of meaningful agenda item descriptions and our claim that no explanatory documents regarding Dr. Crow's legal settlement agreement had been provided via email when the Commission's April 2nd agenda was emailed to interested persons. The 3 legal citations Ms. Lee provided in the applicable case law section all support our allegations of the sunshine violations we alleged. Ms. Lee specifically states on page 4, respondents clearly violated 67.7B. As you know, the City Attorney's Good Government Guide defines material errors in agenda items as substantially misstating the substance of any given agenda item. Given her instructional, since this task force was sworn into office, that you would not countermand, quote, opinions from the City Attorney's Office, we remain hopeful that you will vote unanimously in our favor, given Ms. Lee's apparent concurrence that our allegations are all completely valid. The Good Government Guide and the annual training video clearly stipulate that agenda item descriptions must be included to assist members of the public in determining whether they may have an interest in attending. From the Form 700s that the Health Commission have all signed, as you have, state that under penalty of perjury, they are certifying that they have read the Sunshine Ordinance. In order to certify that, having read the Sunshine Ordinance, they should be fully aware of the contents of 67.7A. Given Commission President Millar's August 20th response to just been doing this all along, because it's been their past practice is no excuse. There's nothing in the Brown Act or the Sunshine Ordinance that permits them to trump either law using past practice.
Okay, we're going to hear Dr. Rivera.
Hi there, Sunshine Ordinance members. What occurred with Dr. Kerr's commendation was a failure to provide a meaningful description of an agenda item in violation of the Sunshine Ordinance. This act denies the public the opportunity to access important information. Clearly, calling it LHH update, quote unquote, is not a meaningful description as required by the Sunshine Ordinance. Members of the public and the medical community, that includes physicians, nurses, hospice professionals, and staffs throughout the DPH, were not alerted that the Health Commission agenda included Dr. Kerr's lawsuit, which had forced Maida Karosi, the LHH CEO, to read Dr. Kerr's commendation in front of the Health Commission. Instead, most of the public and the medical and hospice community found out in the media and after the fact. Furthermore, the reading of Dr. Kerr's commendation was not part of the usual and customary LHH update to the Health Commission, as Health Commission President Millara tries to argue. This mandatory commendation was unprecedented for the Health Commission. I've been watching the Health Commission for 22 years, and never has a former employee who was wrongfully terminated had a commendation presented to them before the Health Commission. Given that this was a once-in-a-lifetime event in Health Commission history, it seems ludicrous that President Millara wants us to believe that Dr. Kerr's commendation did not merit a descriptive and separate agenda item. The settlement in Dr. Kerr's commendation came from the City Attorney's Office, actually, and not Laguna Honda, and was approved unanimously by the Board of Supervisors. Therefore, it's disingenuous to claim that Dr. Kerr's commendation can be adequately described as an LHH update. What the Health Commission and Laguna Honda did by burying Dr. Kerr's commendation under a non-descriptive LHH update item is to cheat the public of the right to know about the wrongdoing of Laguna Honda administration. This wrongdoing includes retaliating against whistleblowers and trying to bury and smear them. Cheating is what Laguna Honda has done all along, right from the get-go, from stealing from the patient gift fund to awarding tainted contracts to cronies. By not giving a meaningful description, they also cheated the public of the right to know how the city remedied their wrongdoing. They violated the intent of the lawsuit settlement and trampled on the Sunshine Ordinance. Both LHH and the Health Commission have shown a lack of integrity. President Millara is not new to the Health Commissioner's Sunshine. She's required to take mandatory training every year on the Sunshine Ordinance. Therefore, it's a willful violation. Thank you.
Thank you. So I first have to ask, are there any members of the public that want to introduce facts and evidence in support of the complainants? You have 3 minutes.
Good evening, committee members. My name's Dr. Derek Kerr, and I'm the one who sued the city and the Department of Public Health for whistleblower retaliation and wrongful termination. No one from Laguna Honda Hospital signed off on the settlement because it was way above their heads. So putting my commendation under the title Laguna Honda Update is just part of a pattern of deception. For example, Laguna Honda CEO, Maida Karosi, was also required to read this commendation in front of the 40-member Hospital Leadership Forum. Instead, she read it before 11 members of her executive committee. After we complained, she complied. Also, Director of Public Health Barbara Garcia had to publish a retraction of a press release that had labeled us as detractors who had made, quote, false statements, unquote, about misappropriated patient funds. Well, the first retraction was unsigned, so we complained. The second version was signed by Barbara Garcia, but it was a memo, not a press release. So we complained again. The third version met the terms of the settlement. Lucky for us, whenever the settlement was violated, we could appeal to the court because the judge was supervising the whole thing. Now we're appealing to you because there's a violation of the Sunshine Ordinance. This violation is symptomatic of a culture of dishonesty. And this type of misconduct will persist unless this task force monitors the Health Commission for compliance. Thank you very much.
Thank you. Okay, can I have the respondent? You have 5 minutes for your case. Take your time. It doesn't start till you start talking.
It's very cold back there, by the way. It's 20 degrees colder. Hello, task force members. My name is Mark Morwitz. I'm the Health Commission Secretary. And you have the response from Commission President Malala in front of you. I'd like just to add a few comments, if I may. In retrospect, and at the time, actually, the Health Commission could have been better advised about the title of the item, and we understand that. It was unprecedented, as I think Dr. Rivero stated, that there was a lawsuit discussed in open session, and we relied on guidance from our legal counsel to help us with that title, and looking back, we should have gone with our gut. And in the future, we're going to be working with our city attorney representative to make our agenda items as clear as possible. 2 weeks ago, we had a joint meeting with the Planning Commission. As you may know, their agenda items are very descriptive, like half a page. And so I took that to our city attorney and said, I'd like to get somewhere between where we are and where they are. And we are going to be working on that. So I wanted to let you know that, as well as the fact that we already did change the way the description of the linkage to documents on the Health Commission next meeting page are listed, and that occurred within a week of getting the complaint. So we thank the complainants for their interest, and I think, at least I hope that they understand that I continue to try to make information as transparent as possible, and I'm here to answer questions or to be here for that. I'm the Health Commission Secretary.
You're the Health Commission Secretary, which is the...
So I am the person who drafts the agenda and the agenda items, and then it is approved by the Health Commission President.
So your staff then. Okay, so the commissioners are Sonia Malala, Dr. Chow, Cecilia, et cetera.
Right.
I was factoring in who's who.
This is my first time here, so I'm not sure. Do I step away, or is it time for questions?
I'm coaching you through it.
Okay.
Your first name was Mark. So your 5 minutes are up. So, yeah, but don't go too far.
All right.
Because we're going to be pulling you back up again. So what happens now, Mark, is that any member of the public can have 3 minutes to bring facts and evidence in support of what you just said. Is there anyone here to do that? Okay, so don't go too far, because what happens next is task force members can question the complainant, the respondent, and anybody that has spoken. And you are now a radio broadcast to me because I cannot see you.
It's warmer at the front, that's why it's called the hot seat. Yeah, exactly.
So I'm going to open this up to my task force members. I'm going to look this way first. Seeing nothing, I'm going to go this way. Oh!
That's all right. The other
These are
members
swivels.
free to question.
I'm going to go with Member Sims, Member David, and then Member Nate.
I don't even know if I have a question. I just think it just seems like they've admitted that they violated the Sunshine Ordinance, and that they have, I'm sorry, I need to speak in the mic here, that they are taking different type of steps to correct their violation. I think it may be up to the either compliance and amendments or education and training to make sure that they continue to comply and that they are following through with what they said they will do and are doing.
I'm sorry, it's Member David and then Member Nate.
Dr. Rivero, please.
Yeah, come on up to the mic so we can hear you.
So I mean, given this, as I believe it was you who said this was like an extraordinary kind of like one-time circumstance.
Yeah.
I guess, I'm wondering if you could wave your magic wand, what would you want from the Sunshine Task Force out of this complaint, right? I mean, we can't go back and well, I mean, maybe they could go back and do Dr. Kerr's accommodation again. I'm just kind of wondering what would be your goal of the outcome of this hearing?
Well, I wanted to just say that we have no grievance against Mr. Norwitz. My impression is that all of these machinations go on way above his head, and, he's just always been a very diligent civil servant who does his job very well, so we have no grievance with him. What we've learned from our experience at Laguna Honda is that if you don't stay on these people, they will go right back to doing what they're doing, what they were doing before, which was wrong. So what I would hope for, because I think the moment's really kind of passed, I mean, I defer to Dr. Kerr about that, rehabbing his commendation, but I think the main thing is that the task force acknowledge and make a clear public statement that what the Health Commission did was wrong, and stay on the task force, the Health Commission, to force them to do it right from here on in. To do right by people. It's a matter of justice.
Sure. So I want to make sure that if we come to a conclusion that it's something that is satisfactory, and so my question is that if we said like, hey, a strongly worded letter to the Laguna Hospital
and the Health Commission
saying, please do not, don't make these mistakes again.
Yeah.
From your point of view, would that be something that would satisfy you?
Yes, and as long as there's follow-up in whatever form you guys want to do it, to make sure that they don't slip back into their bad ways.
Absolutely. And I'm going to ask the same question of Mr. Manette-Shaw.
Okay.
Thank you very much. Thank you.
Thank you, Mr. David, for affording me an opportunity to reply to that same question. On page 191 in your packets, if you would turn to it, there is a list that we submitted on our amended complaint on April 18th, listing 6 separate remedies. We specifically included these remedies because we wanted to suggest to you what it is that we're expecting. One, that you issue an order of determination, not just a strongly worded letter. An order of determination that the Health Commission's president, the Director of Public Health, Laguna Honda's Executive Administrator, and the full Health Commission, who are all named as respondents, violated the 3 sections of the Sunshine Ordinance that are subject of this case, in which DCA Lee appears to have concurred, were in fact sunshine violations. A strongly worded letter, sir, is not enough. Not for me. It may be for Dr. Rivero. Speaking for myself, it's not. 2, you should order the Health Commission to stop lumping multiple distinct agenda items embedded inside of a single agenda item. C, or 3, order LHH's Myva Carosi to stop lumping multiple distinct agenda items embedded in a single agenda item, so that she is ordered to stop doing this also on LHH's own agendas. 4, another remedy that I would hope you would entertain is that you have to order the Health Commission to use standard style HTML formatting to clearly show the usual and customary formatting of hyperlinks on every agenda item, so that people who may skim read the provision that Mr. Morwitz said they have started doing within a week of receiving the complaint, that accident doesn't happen to someone else. Had it not been for Dr. Rivero's inadvertent clicking on that title, we would not have known it was an active hyperlink, and there was a way of making those hyperlinks clearly a standard appearing hyperlink. 5, order the Health Commission to always use meaningful descriptions, not just the agenda item subject title. You need to especially make item 5 part of your order of determination. They have to be ordered to stop using subject titles or even bullet points in a list of multiple items to be considered under a single agenda item. And because give me 1 second. Because the premise was that the Sunshine Task Force needed new blood to make it become more efficient, we specifically asked in item 6 that you notify each city agency, board, or commission that they must use meaningfully descriptive descriptions of the agenda items. That will help you become more efficient by reducing the number of complaints by other parties of this same issue. They should not have to wait the 5 months that we have patiently waited for this case to come before you, when it should have been heard efficiently within 45. Thank you.
Thanks. Thank you. I completely forgot where we are. Are we still at task force members questioning?
Did they do their rebuttals?
Oh, I'm sorry. I was reading all of these. I have to actually thank you. This was I read a lot of these. This was a really well-prepared packet, or whatever you want to call it, so thank you to all 3 of you. So well-prepared, I forgot where I was. So now we have the respondent first, and then the complainant each get 3 minutes for rebuttals and conclusions. So, Mr. Morowitz.
Yes. This is not in defense. I just want to be transparent to show you this is what exists now. This is a screenshot of the...
I know, I just looked.
Oh, okay.
Go on.
Of the website. So am I talking to you, Ali? If someone goes to the next meeting page for the Health Commission, they see this. And at the... I don't have it in front of me. On the top of it, it reads, to access information for the Health Commission meetings listed below, you may click on the bolded items in blue font. All the bolded is usually blue in real life. To view documents associated with a specific meeting agenda item. I just want to make sure you all understand, in case you want to make a decision against us or do something else, that this is what exists on right now. And that was put in as a correction or in response to this complaint.
You have 3 minutes.
I have nothing else to say.
Perfect. Okay, great. So now the complainant gets 3 minutes. Do you want to split those 3 minutes, Dr.?
Would you like?
Then it's all yours.
I was going to offer to split this time again with Dr. Rivero. First, we should note that we consciously chose not to name Mr. Morowitz as a respondent. The Health Commission's bylaws clearly say it's the duty of the Commission President working with the Director of Public Health to set the agenda. Mr. Morowitz is an admirable public servant. He has an unenviable job juggling the amount of work that they do. But it should have been one of the actual respondents who should have appeared tonight. This is not an isolated incident. Past vague agenda items included topics titled Community Health Improvement Plan, Community Independence Project, Proposed Amendments to the San Francisco Health Code, all of which are weighty items that have never been accompanied by a meaningful description. Also, in your packet on page 199, you'll see a chart that we submitted that in the current calendar year, there were 108 agenda items from January 1 to date, 69% of which contained only titles. Of the 108, 22 were action-only items, 12 were discussion-only items, and 55 items involved both discussion and possible action. That's a lot of stuff. A lot of stuff that members of the public who may have chosen to attend a meeting of interest to them were denied an opportunity because of the lack of agenda descriptions. So I'm asking you again, please vote unanimously in our favor and provide each of the remedies in your written order of determination that we specifically requested. I appreciate your compliment, Ms. Fisher, on the substance and the writing in our amended complaint. And I ask that the E&T subcommittee proactively send out notices to each city department to order them proactively into compliance to lessen your workload.
Member Washburn.
Yes, I'd like to move to find violation of Sunshine Ordinance 67.7A, 67.7B, and 67.9A. I'd also like to possibly add 67.21E for failure to send for the named parties to attend. I think there's been a clear violation here. There's no doubt about it. So we must issue an order of determination. There's a lot of history here. There have been some egregious things that have happened, and I don't think this was certainly not Mr. Morowitz's fault at all. But I think deliberately keeping that agenda item vague was purposeful, willful. And I would recommend that, actually, I like the idea of the EOT taking up this project of giving clear guidelines to commissions and different bodies about how to structure agendas. But this might well go before probably compliance and amendments a few months hence, where we have a chance to see that they've started doing the agendas in the way they seem to be. Just to check up on that, I'd like to have one of the named parties come and make sure they understand what's going on too.
Second.
So I heard a motion, but then are there three things happening there? One, it's a violation. Two, we're going to send it to our friends at EOT, and then it's also going to go to compliance and amendment?
It's called the chair, or?
Norm?
I'm going to let Member Washburn answer.
Well, the body of the motion is that we find violation of 67.7A, 67.7B, 67.9A, and also 67.21E for the knowledgeable party to appear. And then those were my thoughts about how to, what to do with it.
I think I know where you're going with this, but go ahead.
Has there been a second?
It's been seconded.
Okay, I would ask that 67.21E be separated.
Oh, well, that's up to you, Member Washburn.
That'll be fine.
Are you? So now we're going to have two motions
Yes.
again? Okay. Okay, then let's go with the, can you read? Well, go ahead.
Public comment.
Well, I'm getting there. I just seems to be that Member David has something to say before public comment.
Yeah, no, I just want to, I think, well, I would hope I speak on behalf of the task force to thank Dr. Kerr for the work that he has done in bringing to light the problems at Laguna Honda. And so I just wanted to kind of state that before we move forward.
We're allowed to do that?
Just did.
While we're out there, I mean, you know, Dr. Kerr, thank you for all the work you've done in the oncology community, hospice. My father was an oncologist at Yale for 51 years, so I know of your work.
I'd also like to acknowledge Dr. Maria Rivera and Patrick Manette Shaw, who has been tireless in keeping this matter before the task force so that we could be as helpful as we could.
Okay, so we have two motions. I'm going to combine public comment. Do I have any public comment from anyone that... Oh, I'm glad I combined it. Who have not offered facts and evidence. Okay. So let's read the motion one at a time, and we'll do roll call.
First one, right, the first one, then we're going to vote on the first one.
We're going to do them separately. Let's read the first one.
First motion by Member Washburn, seconded by Oka, to find violations of 67.7A, 67.7B, 67.9A. And did you want to include suggested referral to EOTC? Is that, or we'll leave it up to the chair as normal?
We'll leave that to the chair.
Okay. That's the motion. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
7 ayes. On the
Motion
second,
passes.
on the second motion, made by Member Washburn, seconded by Member Oka,
Madam Chair, may I offer some discussion on that, please?
Absolutely. Member Nee?
Thank you. 67.21E instructs that the respondent send basically a knowledgeable representative, and I don't think they've failed in that. I didn't hear any questions that Mr. Morowitz was unable to answer. And so I don't think that 67.21E is appropriately brought before us here.
I forgot. Who made that motion, Madam Clerk?
I did.
Oh, okay. Member Washburn.
I guess, no, I agree that Mr. Morowitz answered all of our questions, and we have a clear idea of what they plan to do going forward. It's just the specific matter before us of the agenda item being so vague as to be useless. The commission president was someone who had to give the final okay on the agenda, and she okayed this, and so it would have been helpful to me to have some understanding of why this was allowed to stand, given that this matter was a very big deal, and a lot of people would have liked to have come to hear Dr. Kerr, or this commendation read. So, you know, it was more than just, it was about the agenda item too, but there's a backstory here that we're well aware of. But I guess I'm not hell-bent on, in pursuing it. I understand what Member Nee is saying.
Were you saying, given the gravity of the previous proceedings, it would have been appropriate for one of those named to be here.
Exactly, yeah. Yeah, this wasn't a technical matter or how to put an agenda together. That wasn't the crux of this. The crux of this was the content of that agenda item and the whole history of that. So,
is it possible that we could recommend that if it does go to EOT, we request that one of those named appear before us for that, in addition to Mark?
right, I'd also, but I like I said, I would like to see this come before compliance and amendments. I mean, EOT has a role too, but you know, this is
A little stronger.
Yeah, a little stronger. Give them, some time, and then I would hope to have, I want to hold some feet to the fire, and it's not Mr. Morowitz's feet. He's doing what he's doing a good job.
Your feet are fine.
Yeah.
And hopefully
I got this side of the room.
Yeah, I just want to say that I completely concur with Member Nee, that I do think that they sent someone who was very knowledgeable about the issue, and he was able to answer all the questions that we had. And I also agree with Member Washburn that I think that compliance is the appropriate, at least first stop for this case. So that's it.
Okay, then I'm willing to withdraw the motion if the second will agree. If we can send this to compliance and amendments.
It's fine with me.
Okay, thank you.
One motion now.
So we have one motion. It's been voted on. So a violation has occurred. The chair is now going to assign this to the appropriate committee. Dun, 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 dun. So from what I've heard, it sounds like compliance and amendment is the place to send this to. We can discuss this. I'm leaning that way. Member Washburn, since you brought that up, I think that's where this should go.
Yeah, I think it's important given the history here.
Okay. So, wow. Passed? What happens now? Remember, move on to the next one? You better have this one. Member Sims, yes.
Just before we move on to the next one, I unfortunately have a flight that I have to catch.
That's right,
so I
you
want to
do.
apologize to Mr. Ringo and the planning department for not being able to listen and be here for their case.
How much longer can you stay with us?
I was going to say, mine's pretty quick. I don't have that much to, but you have to go.
Probably 15 minutes.
Okay, we'll each get 5 minutes.
Okay, yeah.
It's possible I could
I'll
be done.
listen, yeah.
I don't have a whole speech. I'm not reading.
Dr. Can you please read that?
Point of order, we have to approve jurisdiction first.
I need to read the item.
We haven't read the item yet, though. Yeah, to read the item, right?
Item number 8, file number 13024, complaint filed by Micah Ringel against the Planning Department for allegedly failing to provide requested doc records associated with the proposed development of 480 Potrero Avenue.
Good evening.
Oh, do we have jurisdiction?
So move.
Oh, it might be longer then.
Second.
Second, okay, so, can we pass that without objection? Do I have any public comment on the motion? Hearing none, can I say that we've passed that without objection?
Okay.
So you're the only two people left in the room unless there's someone behind you.
All right. So, my name's Micah Ringel.
And you have 5 minutes, go ahead.
And there is a planning department project that's now been approved to build a large building across the street from my house. And I went to go see Attorney Sue Hester, land use attorney, and she suggested, because I can't afford to hire her, she said, go down to the department, you have to view the case files. She said, ask for more than just the public case file. I didn't know there were several of them. You ask for all the case files. Make sure you ask for correspondence. And so I sent very cordial, polite emails to City Planner Ben Fu and Environmental Planner Don Lewis requesting, can I please see the case files? Please make sure they're complete. I've been told to ask for the complete case file. And Don Lewis quickly responded, and I went in the very next day to go see the case files. And I noticed there was documentation missing because for a CEQA case, they released the PMND. So there's stuff referenced in the PMND that did not exist in the case files. But I've never seen a planning department case file at that time. Now I've seen dozens of them. So I needed to see the other case file. Let me explain the other case files. Each planner that has, like, if one's doing the shadow study, if one's doing the traffic study, every case file has a letter at the end of the number. So for environmental file, it's an E file. If it's a large project, it's an X file. If it's a shadow study, it's a red. So, and Ben Fu did not respond for 10 days. So I sent another email saying second request was actually the entire gist of it. And he said, if you're making a request under the Sunshine Ordinance, then you need to contact Lulu Huang. Otherwise, I will have my case files available for you tomorrow. And I didn't know what the Sunshine Ordinance was. I had to Google it. Thought it had to do with sunlight. It's like, oh, wow, okay. Well, I don't really need to do that. And so I went in to go view the case files, and the documentation was missing. I didn't know what to do. And specifically was the correspondence folder was missing, the graphics folders were missing, and some of my correspondence and correspondence from my family that were submitted during the public comment period, which is actually a very short period, to say how you feel about the folder was literally empty. So I didn't know what to do, and I wasn't going to ask the planners whose files I just saw, so I contacted Lulu Huang, and who's actually lovely. Like, this isn't against her. Like, she's got caught up in the middle of this because she's the office administrator in charge of the Sunshine. I just want to make that clear. And so you all were speaking about 6721B. If anything, those planners should be here. Like, they're very much like the ones who should be here to explain why they have not complied with my request. And by request, they've now built up the case file. So a lot of what I was looking for was finally made available. It's not a question if they did not comply, it's a question of how much did they not comply, because I asked for everything that the planning department has for the address. There was a project plan that wasn't built in 2002. I wanted to see everything. It should be up to me to decide if it's important, if it's not important. June 6th, after I'd been told in all the emails that you all have in front of you that I had had everything, there's nothing else, 4 folders for the current project were made available that had been sequestered on the 5th floor of the department. They were the U file, which I never knew existed. That was the original preliminary files. And what's ironic about that was the neighborhood group, who's also opposing this project, she asked for a document that we knew existed, and she got sent a document that I had never seen before. Because she forwarded it to me, and she said, I asked for this, and I got this. And I'm like, wow, that's interesting, because I have a Sunshine Ordinance complaint against the department. And it was just days after that, I think they realized, oh no, we've released more information. And some of the stuff I got is really important, like a failed shadow study that was not discussed in the negative declaration. You can't have technical reports and then just choose the ones you want to and not. So what am I looking for now? Because the planning department's already granted the project. I'm so thankful that you're having this hearing now, because a week from Tuesday, or no, this next Tuesday, is the Board of Supervisors is having that appeal. And so I'm right about ready to go, after that. I've already not had stuff I've needed to prepare. I have 20 seconds. What am I looking for now? I asked Ms. Wong if she can have a computer admin go onto the servers and pull the correspondence related to the project. The correspondence is not privileged between the department and the developer. They haven't provided anything like that, and I don't even know what else exists. But some of that stuff's important to me, at least. Thank you.
Since this is your first time, don't go far. You're going to have a lot more than 5 minutes. No, you have to go away now so that the respondent, but then you'll have plenty more time. We'll be here all night if that's what it takes.
Thank you.
Come on. Well, except for Member Sims, who has to be somewhere. So now we're going to hear from the respondent.
Madam Chair,
hold.
just briefly, it should be noted that there is nobody in the public section to offer facts and evidence in support of the complainant or the respondent.
Benefit of the recording.
For the benefit of the recording, as Member Nee has just stated, there is nobody left in the gallery to offer public comment other than the respondent and the complainant to this item. Come on forward.
Madam Chair, good evening, and members of the task force. My name is Lulu Huang, and I work for the planning department, and I take care of the sunshine requests. I don't know many times because when I first get the complaint from the sunshine task force from Micah, and the first thing I asked him, what did I miss? Can I help you to find the material? Because I really don't want to be here. I know you don't want to be here either. So I really try to help him out, whatever. So for the very last moment, I will really get the court date and time. And it so happened a couple days before he was at the planning department, so I asked him again. I said, what can I do to help you to find the material? So he explained to me again, like he says, the correspondence file was empty. I am wanting to know what's in the correspondence file. So I sent an email to Don and also Ben. I said, please help me out. This is what I need. Can you tell me, and can you provide me what he wants? So Don replied, I said, I already given everything to the gentleman, and that correspondence file that he was referring to is not mine. So Don is off the hook. So it comes to Ben. So I asked Ben, okay, what can I do? So he told me that because whenever there is a sunshine request in our drive, I open a folder. I say, put everything into the folder, then I will know to make a CD. When the person come with the case file, then I will either myself or the planner themselves will give it to him. I do not know. I really do not know whether this was ever given to him, but I went to the 480 address that he was requested. I copied everything. Whatever I have besides the case file is here. So I hope that if I give this to him, he reviewed it, and if he's still not satisfied, I will go find it. But as for right now, this is what I have. Okay. So would you like to have it?
Yeah, thank you.
Okay. Thank you.
Thank you.
So, Mr. Ringo, hang on a sec. Policies and procedures here. We don't, for the record, we don't have anybody in the gallery to provide support to either the complainant or the respondent. So now I'm just going to turn over to the task force unless Member Nee has something else.
Very quick question, Mr. Ringel. What is it, and this is just a technical thing, but were you asking for actual on-site access to the documents or for copies thereof, or both?
Well, it's normally department policy to make them available in the file viewing room.
And what were you asking for?
I have specifically...
No, I mean, were you asking...
I was asking for all correspondence, all files, digital or otherwise. SEEK was very clear that there is nothing privileged between the developer or not.
No, let me rephrase the question. You said the practice is to make the files available in the viewing room. Is that what you were seeking? In the viewing room or copies sent to you?
Oh, no. I didn't know how it worked at first, so I just thought maybe I didn't know what to think. But they make them available. They're at the front desk, and you go and you check in.
So that's what you wanted, was on-site in the viewing room?
There's stuff in this negative declaration that does not exist in the case files.
Okay, but
I'm trying to find out. I would like the opportunity to review.
I'm just talking about.
It would be great if
I'm talking about form and location now, not content, just form and location.
Oh,
you wanted on-site viewing, right?
Anything.
Okay.
I just wanted to be able to. I want to.
Okay.
I have comments. It's not. It doesn't exist in the case file, and it's really frustrating. I have it. Like, I actually have the emails here, and I'm kind of like
you just wanted to view them on-site.
I want to make sure they didn't go anywhere. There's a problem when there's stuff referencing in a negative declaration if it doesn't exist in the case folder. Okay. And I did get these twice, and I think I even got some emailed to me and stuff. One, they reference attachments which aren't here, and two, this is not complete. these are mostly my emails, unless this is, I'm sure it's a new one. Maybe it'll be much more substantially in compliance, but a lot of what the two CDs I got before were my own emails to them, and which I thought was kind of funny, and they weren't even the earliest ones. And some of the stuff is important, like you have our district supervisor wrong on the cover page, and fascia air, it's like right there. And then they revised the document, and they failed to update the document with the proper supervisor, which to me is misleading to everyone who reads it, thinking, wait a minute, where is this? What is this? And it kind of shows a pattern of some of the procedural and substantive issues. And so the fact that I'm here right now to say, can I have the documentation that was sent right here on October 1st, and I have it, but I don't know what else was sent on October 1st during the comment period that was just disregarded, because my own comments and comments from my mother actually is the one who told me to do this, because she wants to make sure, see her comments in the file. So I'm kind of doing this for the family. And again, it's nothing against Lulu Wong. She's really been very accommodating and tried, and I know she went to go look at the old folders and stuff. It's not her, and that's why I think 6721B in this case, because the planners know it's they're the ones who've made they're the ones who made a decision to not comply, despite my asking several times.
Don't go too far. Do you have any other? Member Washburn?
So
I could always count on you.
So there's still some, as far as you know, well, you haven't had a chance to look at the latest CD, but you requested everything related to the case, and you got very little at the beginning, you got more later on, and at this 11th hour, because a big hearing is coming up, you need everything, and
I do need everything. I actually needed everything the planning commission hearing when they actually approved the project. This is now going to be an appeal to it, and then it's one step for CEQA before you go to Superior Court. And so I know the Superior Court will give me, I actually called Andrea, I think almost crying right after the planning commission hearing, saying, I totally feel like my civil rights are being trampled on by the planning department, by actually these two planners, Don Lewis especially, because he's an environmental planner, and he knows CEQA. I mean, that's his job. And for him to say, I've given you everything, you're not getting any more, I don't have to comply in the least with the documentation between, nothing. And it's like, well, my own comments from the comment period aren't represented in your negative declaration. So if mine aren't, I don't know who else's aren't. And so, yeah.
Can I just get a clarifying question? Were your comments during the negative declaration oral or written?
Oh, they were, I have here my mother's emails sent to them, so that's written.
Right.
And then I have him responding to, I received your voicemail. You are right. The project site is located in District 10, Malia Cohen. That was in October. The document was amended in April to be adopted. And the amendments, it was not changed because there were no substantial changes, and so it was adopted with the incorrect information that provided in October. Also was information, I'm concerned about the environment. Please contact me, and so making these references, and then the negative declaration itself says no one had any environmental concerns. And so I'm trying to levy those two.
I got that, but very specifically, so
both.
Okay, so one of the issues with the Sunshine Ordinance is that if a document does not exist, it doesn't need to be produced. So that's why I was asking if your specific comment was oral or written.
So my comments were written and I guess via voicemail, but what doesn't exist is his response to the voicemail that I have. And so if I have it here from October, why isn't it in the case file?
So you have a written response. You personally have a written response.
Received your voicemail. You are right. The project site's listed.
And you're saying that was not put within that was not in the information that, okay, perfect.
So basically, the more you've dug into this, the more you've realized is absent, but you don't know the full extent of what might be there.
From my perspective, Dave, I know what I was given in June was I had been told for months, since April, since I opened up this complaint, you already have everything you have. Like, there's nothing more I can give you. From Lulu, she's saying, she tried to mediate, and that's what they told her. Other than, they know that's not true, because in June I got this many more information for this project, and then a whole box from the 2002 project, and then I find that some of the documentation from the 2002 project was resubmitted for the current project, and it had literally been stolen. The developer didn't photocopy it and then say, here's a report for you. It came from the 2002 folder that he'd previously accessed, and it's not in the 2002 folder anymore. And then I bring this to the department. I know that's ethics, but I bring this to the department's attention. Are you going to investigate? Does anyone care? And I receive no response. And I bring it up several times, and then it's just like, all right, well, now it's time for a hearing.
Did you at any time submit an IDR?
What?
Immediate disclosure of information.
What's the IDR?
It's on the
Immediate disclosure request.
Oh, the immediate. I didn't exactly know about the process, but no, I requested to see the case files. No one, even if I did, what difference would it? I mean, it wasn't like I wasn't in contact with them.
We're trying to pin this technically, so you have to help us here. If you've done that,
And we realize you've basically become an accidental activist, for lack of a better word. You get thrust into this.
I don't want it.
I think you mentioned in your earlier talk that one of the representatives suggested or asked you, is this an SOTF request?
Oh, he said, well, it was...
And then what did you do subsequently after that? How did you phrase your next request? For
Okay, yeah, I'm sorry, I have that here. Ms. Wong, I have the correspondence. What exactly are you looking for? Right here. Sorry, it's backwards order, so then it's... In preparation for the hearing scheduled for May 16th, I'm requesting a copy of the complete file for the proposed development at 480 Potrero Avenue. Please include all documents in addition to any emails and or electronic forms of data which you may have for this project. Please let me know when you expect this packet. The reply after not from 10 days from Ben Fu. He replies, if you're making this request under the Sunshine Ordinance, please contact Lulu Huang. Otherwise, if you wish to review the case file, it's available at the 4th floor reception. I emailed Lulu Huang, and then she didn't reply for 10 days either. So that was sort of... But I did that after I went in to go see the case files. I think I just said that. And that was to... There was definitely stuff missing. So then I made a third request to Lulu. Now, you too have not replied for 10 days. Now, I honestly do believe that that was accidental. It wasn't like... But... It really goes, I don't know what the procedure is. Can you just, if someone wants to view a case file, can you just say, well, go ask someone else, and then if they don't respond, then what are you supposed to do? And then they never did comply. Did that answer your question? I'm sorry.
Yeah, that's starting to answer my question.
As far as, I did ask at one point, like, I'm running out of time for the hearing and stuff, and Andrea sent me a link. I think it was to not Dennis Herrera's. That was the thing. It was to George Gascon or something. Is
He's the district attorney.
Mm-hmm. But that's Dennis Herrera, right?
No, city attorney is Dennis Herrera. George
So it is because I went to that website, and that seems like if someone's trying to mug you or something, then you.
Yeah, he's the prosecutor. Yeah. He's like on Law and Order, the prosecutor. That's George Gascon. Yeah.
Yeah, it didn't make sense to me though when I went there.
The city attorney represents
that would
the
make
city.
sense to me though. But see, because he seems more like that's where this would fall. And so I went to George Gascon's website, and I didn't know how to. I didn't know how to.
Yeah, we have a city attorney sitting right here.
Yes, deputy. I'm aware. I'm learning the process.
I have a question for Ms. Wong.
Bring it on.
Ms. Wong.
So, one of those things that raises people.
Are you in agreement that there are documents that are in existence somewhere that I'm sorry, I forget your name, I apologize, sir. Mr. Ringgold, that he is not in possession of? Or do you feel that he's in possession of every document that he has requested at this point?
Yes, because I talked to the two planners personally. I said, is there anything else that you can give me? Because this, several times this project was requested. So in many stages, I saw the planner bring out the document for him to review. So I believe, and they told me, that they already given him everything. So the only thing that he said, make the copy of the iDrive, the folder. That's it. That's all we have.
So I guess I'm a little bit confused about this one particular email that he's using as an example,
Right.
saying that this was not in the. So do you have an? Yeah.
Okay, I did ask Ben. I said there is a particular email or correspondence that he's looking for. Where is it? How come the correspondence file is empty?
Right.
So he said, I put all my email in a digital file that is in the CD right now.
That you just handed him.
Yes. So that's why I say please review the CD and hope that whatever he was looking for is in the CD. And if it is not in the CD, I will personally go chase it down for him.
Okay.
Okay.
So Mr. Ringel, when is the Board of Supervisors hearing? Is it Tuesday?
It's Tuesday, yeah.
No. It's already been to planning. It's Tuesday.
Board of Supervisors, yeah, no, it's Tuesday. I'm actually, my request kind of was, because the planners were non-compliant since Ms. Wong's the administrator for Sunshine Ordinance for the department, was to please call the IT admin and ask them to go to the Exchange server, which is the email server, and copy, do a search, 480 Potrero. Both of them have only one project on Potrero. Please pull for me off the servers the Potrero correspondence. Probably someone would have to go through and redact it, although I'm pretty sure SEQ was clear that there is nothing to be redacted at this point. If I were to bring a lawsuit, which possibly might have to happen next week during discovery, they're going to say that even the draft versions of the documents are legally, you even get the drafts to it. Even those aren't protected in the end. But the effect that this has had on trying to oppose a project, and especially because CEQA is all about maximum public disclosure, it's the guiding principle to CEQA. I mean, it's to create an informational document. And as someone who, there was only a few people who were able to, in the short amount of time, give comment. As being one of them, and my own comments weren't considered, and then the documents were revised, and actually in the correspondence given to the commissioners, that wasn't there. It's just sort of been a pattern.
Yeah. So I think Ms. Wong is doing an amazing job of trying to, accomplish. What I'm concerned about is that there does not seem to be, the planning department is not appropriately keeping public records.
Perhaps our institutional members can shed some light on past cases with that particular department. Is this an EOT issue? Is this a CNA issue? I mean, it clearly sounds like there are some violations here. We have to put our finger on what they are, and at least get that moving forward, and then decide what to do with it. Do you want to take a stab at what violations you think have happened?
Well,
or if?
Through the chair, since I'm being asked to take a stab, my guess, if I was to make a motion, it would be 67.21A or B. I'm not sure which one. And this goes back to the reason I asked Mr. Ringel to tell us whether he wanted on-site access to the documents or copies of the documents.
I don't think I could afford copies, to tell you the truth, at 10 cents.
Okay, so you wanted on-site, you wanted to view them on-site.
I would love them digitally.
That's all I wanted to know.
Anything. I mean, I'm flexible.
Okay.
Yeah.
But you wanted on-site, which would be 67.21A, not B. 67.26 for failure to keep withholding to a minimum. 67.27 for failure to justify what the withholding, and possibly 67.29-7 for failure to maintain records in a professional and business-like manner. Short of a formal motion, I would put that out to the consideration of the members, but I believe, Madam Chair, I wanted to ask if we've yet had our rebuttals.
We have not. We are still in the discussion period.
Okay, before bringing a motion, I think it would be appropriate to hear rebuttals and concluding remarks.
Okay, now we move into the rebuttal and concluding remarks part, and we go in reverse order. You went first last time, she went second, now the respondent goes first, and then you go second. So you, if you would like, you have 3 minutes to offer rebuttals or conclusions. If you have nothing to say, that's fine too. Or you can get up and read Dr. Seuss for 3 minutes.
Well, the only thing that I want to say is the planning department, unless it is the city attorney client privilege, thing that cannot be shared, we try our very best to share everything. We may be sometime missing a file because these are, let's say, 2002 or till this is 2013. There may be a few dockets, and every docket's been reviewed probably by different people and stuff. But our job is to provide the client everything that we have. We will never try to hide everything or try to hide anything. Okay, thank you.
Thank you.
As a mission, I believe that's true. It's like a mission policy. And probably in most cases. But if planners have said things and they're not in the case file, then do they exist? If they don't have the paperwork there, allow me to explain some of when they posted the negative declaration, the site was a parking lot for 50 cars illegally for months and months and months and months and months. Yet they described it as a vacant lot. And so part of the importance of seeing the graphics folder is to see what are the pictures. And when you finally get given the pictures after you make a big deal about the graphics folder, and the pictures have cars there, and so it's like, okay, so no, they knew it wasn't, because I couldn't get it from John Lewis or Ben Fu, I ended up getting it from the zoning administrator correspondence, and then it shows correspondence in between them of them colluding about the parking lot issue. Wait a minute, what are we going to do about the parking lot? Do we need to address this? Do we need to address that? And it's like, wow, see, there's really stuff there. I see now why they didn't want to give me the correspondence. And so, from my perspective, I asked for the case files. If the shadow study is sequestered on the 5th floor, and then you finally get access to it right before the hearing, and you find a failed shadow study, it's like, no wonder they didn't want to. No wonder why, when I went to go speak with Supervisor Cohen, she said the first thing the developer asked me about was, what do I think of shadows? And there was a whole story there. I told him, I'm not afraid of mine. And it was like, then I find this, shadow study. And it was just kind of, to me, this is actually deliberate, it's poignant, and if I could get all the correspondence they have for this project on a CD-ROM would be awesome, but if it could come from someone who's not them, because all they've ever given me is my stuff or stuff that's benign or not. Yeah.
Okay.
Thank you.
Thank you.
Do I have a motion?
Madam Chair.
Member Nee?
I move to find respondents Don Lewis, Lewis, and Ben Fu, Benfu, in violation of Sunshine Ordinance Sections 67.21A, 67.26, 67.27, and 67.29-7. 67.21A for failure to provide all requested records in a timely manner. 67.26 for failure to keep withholding of requested records to a minimum. 67.27 for failure to justify withholding of records. 67.29-7 for failure to maintain records in a professional and businesslike manner.
Member David?
So,
Point of order, is there a second?
Oh,
I second.
okay, sorry.
sorry about that.
We're like, oh.
So, Member Nee, I completely agree with you on 67.21A and 67.297. I guess I have a question about 67.26 and 67.27 because I didn't see them trying to justify withholding. It seemed to me that it was more of an institutional failure than saying that there was some type of privileged withholding, right? And so it wasn't that they were saying that, oh, we're withholding this document because you don't have a right to it. It was more like, we're withholding this document because proof it's in the air. Like, they didn't acknowledge that the document actually even existed, and so that's where I'm a little
So you're saying you believe that the withholding was inadvertent?
Correct. Yes. Once again, I think that 67.21A, I agree with 100%, and 67.29-7, maintaining the public record, seems to be a huge problem. I seem to think that the withholding was inadvertent. It was not purposeful. That's just my opinion. So I don't know how other people feel about that.
Well, as far as 67.26, I don't think we have to determine a reason that records were withheld. We just have to determine that they were withheld. We know that they were withheld. We know that there were, over the course of this whole document request process, there were records withheld from the very beginning. More would be given, but that was what brought him here, and they were just being withheld. And part of the ordinance is if you're withholding records, you have to indicate that you're doing that and give a reason for doing it.
You have to cite the specific provision in law that allows you or requires you to withhold a record.
I'm not arguing that point at all. I guess my question is that if you're not aware that you're withholding it, then how do you cite that's kind of that's
I understand.
Yeah. So I guess once again my question would be, can we split the question into the four different
the question or the motion?
The motion, split into 67.21A, 67.26, 67.27, and 67.29-7.
You'd like it split into four motions?
I'm more than happy to split into two motions, 67.21A and 67.29-7 as one, and then 67.26 and 67.27 as a second. That would be fine with me.
Madam Chair, that's acceptable to me.
So we're going to have two motions?
And the second accepts.
And the second accept. Go ahead. It's just us. Come on up.
It's not like I asked once or twice for these documents. I actually emailed anyone who had listened. I started emailing people up the chain at the department saying, I know there's information in the case files. It wasn't like I was quiet about this, which was actually, in retrospect, probably a bad idea because I know I embarrassed myself by emailing anyone who I thought was their supervisor, anyone who was in their department, trying to get some sort of response. And they were all very clear. Why is your graphics folder empty? Why is your this, and they were willfully withholding it because the files existed, they just weren't making them available. And to say, you've been given everything, and they note, and then something accidentally gets released, And then it's like, oh no, but we now need to give him that entire case folder because it came from somewhere. And all of a sudden I get the shadow study folder,
Mr.
which I didn't
Ringel,
know.
let us figure out what we're going to do to make this remedy. I think we're doing okay here. We've got two motions. I didn't mean to cut you off. It's just, you can come back and talk again, I think, but...
Madam Chair, I think we should also note that, again, that there are no members of the public in the public section of the room.
For the record.
For the record.
There are no...
So noted.
So noted. There are no members of the public in the room.
Outside the parties.
Outside of the parties, the complainant and the respondent. At 8:20 p.m. We have two motions now on
That's
the...
correct. One motion is to find Don Lewis and Ben Fu in violation of 67.21A and 67.29-7. The other motion is to find the same gentleman in violation of sections 67.26 and 67.27.
Okay, let's vote on the first As there are no members of the public for public comment, let's vote on... Can we take a roll call vote of the first motion, which is 67-21A and 67, can't even read my own writing, dash...
29.7.
29.7?
Yeah.
Okay.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Simmons is absent. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye. So the motion passes.
You have 6 ayes.
Yes. Okay.
On the second motion, you want ready?
Yeah, go ahead, read it.
Okay. So on the second motion, which is 67.26 and 67.27, Member Nee?
Pass.
Member Washburn?
Aye.
Washburn, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member Nee?
No.
Member Nee, no. And Chair Fisher?
Aye.
Fisher, aye. 4 ayes, 2 noes.
So that motion does not pass.
Madam Chair,
Member Nee?
the reason I voted no is to be on the prevailing side of this matter. At some future date, I may bring the motion back to find those particular 2 violations. Being on the prevailing side of this issue gives me the right to do so.
Okay, so noted.
Very sneaky.
What?
Learning.
So we have found, wow, what to do now?
Madam Chair, I would
Member
recommend that the
all
matter go to
yours.
compliance and amendments.
CNA? Okay, so we're just dumping on our buddies. Oh, well, that's your committee. So I'm going to recommend that we send this to compliance and amendments at your next meeting. So this pops up your next, because this is kind of time sensitive here, right? So this goes to the next meeting.
Well, it's not going to help him for Tuesday, that's the thing.
I know. Madam Clerk, this goes in the minutes, right? So this is like tomorrow, so, well, in the next few days.
I have 10 business days.
10 business days,
But it's on
okay.
audio, and audio will be at within 72 hours.
So you've got that, Mr. Ringel? Our audio will be up in 72 hours.
And Mr. Ringel, you also have a new disc, right, that potentially has, I'm not saying it does, but potentially has all the information. And it sounds like you have Ms. Wong who's willing to work with you, So I suggest go look at that disc and be in touch and see if there's anything missing and try to get as much, whatever information you can get by, that's, I think, the most we can do.
And you've been to DBI over at 1600 Mission, you've met with the people there, right?
I've been to DBI, SFFD, I've been to the Department of Public Health, I've been to almost every agency that has documents and record requests. Everyone has been awesome.
I did the same thing you did 9 years ago.
Oh, yeah?
And ran into Sue Hester. I think she just hangs out there.
Yeah, no, I see her at the department all the time. I think, to me, she's a great San Franciscan, but that's, yeah.
Yeah, I ran into somebody there who was working for a developer who pulled me aside and said, "You're on the other side of the city. Come here, kid. Let me show you how this is done. I'm going to do this for you for a few hours." So they are really helpful.
She gave me the instructions that got me actually into a lot of trouble, which was sort of, she said ask for everything, and I asked for everything, and then I didn't get it, and I didn't know what to do, and so that's how I ended up here today. So thank you very much. Thank you.
Good job.
Yeah. Thank you.
Thank you, Ms. Wong-also.
Thank you.
Nothing.
No, we will be in touch with you if it will be sent to compliance, and you'll get a letter and all that.
Notice to appear.
Yes, but continue to help Mr. Rangel as you have been, and that'd be great.
If possible, ask an admin from their emails from the Exchange server put in 480 Potrero or
Guys,
Potrero.
we're gonna go on with our meeting.
thank you.
So, I mean, you guys feel free to go for coffee or something. Or something stronger.
Thank you both of you.
So yeah, this matter is concluded, and we have items 9 through 19. So yeah, remember me.
Madam Chair, because it's getting kind of late, I would move that items 9 through 15, which are minutes of previous meetings, be continued until the next meeting.
Do I have a thank you? I have a second from Member Highland. For the record, there is no one in the gallery, so I'm not even going to mention public comment.
There's nobody but us.
There's nobody but us. There might be some mice in the back, but that's about it. Okay, item 16, Compliance and Amendment Committee.
I'm trying to remember. I think we had the matter of Ray Hart's and the. I didn't double check the minutes, the draft minutes, but I believe that we heard the Ray Hart's matter with the Library Commission failing to give equal access.
The boomerang.
Right.
Yeah.
Right. So that was the only matter on the agenda.
Okay, well, you have another 4 minutes and 32 seconds if you'd like to elaborate.
I yield my time to the next item on the agenda.
Okay, item 17, Education Outreach and Training. That is Mr. Pilpel, who's, Mr. David, you are the Vice Chair.
Yes, and so we heard two cases, the Art Commission versus William Clark, and that was continued as they seem to be making progress towards a resolution. And then Mr. Charles Pitts versus the local homeless coordinating board, and Mr. Pilpel is going to go visit one of those meetings and see if he can offer some assistance. And we are going to hold, according to Mr. Pilpel, our next meeting relatively soon.
Any comments? Anyone? Otherwise, we can move right into Madam Clerk, the Administrator's report.
The Administrator's report should be before you. I won't go over it to read it. It's pretty self-explanatory. But do you have any questions?
I think we're pretty familiar with it by now. Does anybody have any questions? Hearing none, we'll move to item 19. Yes, Member Nee?
Yes, some of you may know that applications and nominations have come forth for the two vacant seats, numbers 1 and 4.
Oh my God, tell your friends, yeah.
And I would strongly encourage members of the task force individually to contact the Board of Supervisors Rules Committee and urge them strongly to move forward with these appointments. This is a matter of making it easier to fill our quorums. We came close tonight to not having a quorum. Also, this gives us greater flexibility on committee appointments. So
Yes.
I would urge my colleagues respectfully to contact the Board of Supervisors Rules Committee on this.
Yeah, and Chair Grant and I have been discussing this with each other, with the clerk of the board, with the supervisors, because, we're getting sick and tired, too, of coming to these meetings. It's like when I played soccer and the coach would yell at the people who were there for the people that weren't there. It's like, And so, the other side to this too is if, and I'm going to look this way since these are the seats that are open, if you know of people that are qualified for these very, members Washburn and me, for these very specific seats that are open, by all means, please encourage them what a rollicking good time this is here and get them to, I saw that, DCA Lee, get them to come on down. I mean, that's how we got Member Oka. We went out and found him.
And for the record, I have individually visited Supervisor Cohen's office, Supervisor Yee's office, and Supervisor Breed's office, and encouraged them to make this a priority. So this is something that I think individual members are, or at least I should say, I know that I have gone in and said we need bodies on this committee.
Are there any other, item 19, any other announcements, comments, questions? Hearing none, do I have a motion to adjourn?
So moved.
And seconded by Member Oka. The October 2nd meeting of the Sunshine Ordinance Task Force is hereby adjourned. Aye, adjourned. Aye.